We'll end here. Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. I'm back. Hello, everybody. Welcome. I'm Ada K. Today we are here on day 27 of the Monica Sementilli Red Room trial. Will Baker testify today? The rumor mill, they were going to have him testify tomorrow. The rumor mill was they were going to, prosecution was going to end their case in chief tomorrow, but no. Instead, we are still listening to the happy, breathing, whispering conversations of Monica Sementilli and then boyfriend/fiance. We're back at it again. But they are legit. Supposed to be done today and going into the oh my God. And guys, we have some documents that have dropped. Thanks to Adam General Drop, of course, our fabulous partner in crime has Apple Drop. Please go over to the Discord, click on the link, then please validate your account. And then you can have all the fabulous documents that we have. We've got two that have just dropped from the Karen Reed. We will go over those during break time. We are already, because of Lori Gallo Daybell, about 30 minutes behind schedule on that. I'm glad I pushed it when I did, starting a little early on this end of the boat. So let's go live over there, and we will catch up. I'm going to, depending on what is being said, I may just zoom through this part because it's more of that heavy breathing, whispering stuff. What?
Yeah, I just feel like if we're going to have a 6-year term, I'm going to keep you for
let me. My bad. I thought I pushed the right button. I guess I didn't. Okay. Now y'all can tell me. Do you want me to zoom up and catch up? This is off. Do you want me to zoom up and catch up? Or do you want to listen to this?
That is that's a dream come true.
I'm waiting for the girls to get Tony Grown first. There you go, Mr. Jim.
Oh, honey boo, we can zoom in. We are now live. Hello, everybody. Thank you for joining. Okay, now we are at live. It's very hard to hear this. We have to push through. Can't move it faster now. I'm caught up.
This due process is not for our faith, especially that one. So, we'll figure out something. So many things that we lost. I wish you were in Costa Rica. Yes. No.
Sorry, I haven't seen Miss Kevin in ages. My favorite. Well, yeah, she was my first mod boss. She was my first mod. Miss Kevin was my first on everything on this channel, and she is always and always will be and is an honorary mod, whether she likes it or not. Love you, babe. Thanks for being here. Hello. We missed you, babe. I got to give you your wrench back. You're going to always have a wrench, babe. I don't know why it's gone, but you will always have a wrench, whether you like it or not. You don't have to do anything. You don't mod with me. Just easy. You were so loved, my dear. So loved.
It's all gone now. It's all gone now. Too late. It's all gone. Everything's gone. You know, they wanted to meet all that shit. But I'm still. So one option. You know, PP, tier PP.
If I ever change PE, it's because they're either going somewhere or something like that.
Yeah, but usually about 10 I'll give that information. Because 14 days later, you have 14 days of possible stuff that's coming up.
Yeah,
So that's why I was like doing it.
I know, but
See my point? I ain't gonna
she's like, to me to find out her release date.
Good, well, trying to find out
Yes.
which one is this.
Everything's frozen, all her money's frozen, my bank account's frozen, the house, I'm not gonna sell it. Probate lawyer's trying to sell it, their own real estate agent, I can't use mine.
One thing, all because they're fucking around.
Yeah, because his family doesn't want to take everything, so we have a lawyer that works for both of us, that splits everything out for his heirs and for his children.
Yes, welcome back.
And me. But once this is over, then it doesn't matter anymore, but still.
You know, one of the things.
Gotta give the car back.
Cares something about it.
So they're doing that too,
Why do you gotta do that? Who cares? Okay.
because it's 60
How
grand
are
almost.
those
and,
lovelies,
I
Miss
need the money.
Kevin? How are the babies? All your kiddos. I miss.
The lawyer, the probate's not gonna pay for my car, you know, it has to be family bills that are paid, half and half. I sent you a lot, so,
Within the last week, right?
yeah,
Yeah, it's gonna be a couple more minutes.
I hope we get them. It's like, 'cause if you don't, it's like, I don't even wanna write, like, I write, but I know it's not going anywhere, now you're never gonna see it.
Yeah, so just go, you know, PP. For now. Let's see what happens. Just.
I sent you, I swear I sent you now. Already, cause I check it there, right, before I send it, check it. Already to send back one paper, and it was a little lipstick on kisses.
They send it back.
Yeah, because you know, it's contraband, you can't put lipstick, you can't put kisses. It was lipstick.
All right.
Looky, Miss Kevin.
Yeah, and that was the one I wanted to give you. Actually, didn't care about the rest of them. Yeah, so you're not gonna get half the shit. Cause I drew up all of them, I kissed them all,
Okay. Sorry, I feel it anyway. And seeing you is just fantastic. Seeing you is fantastic. You should. You should. Do it. Yeah. Me and you and I. Yeah. So we're gonna tell them, how we're gonna tell them when I get there, we're gonna do this. Then you really push this on. We're gonna tell them.
We need to wait till the. Let's see what happens.
I'm not going there. I can't testify against each other. Not that I would never. That's the thing. Say about that.
Yes, we need to welcome again, Miss Candace. Oh, thank you for coming to the Zoom.
I also told you that. I told you that I was going to go this is before. You see you do that thing. They will be okay. Give them credit. Give them credit. They will be okay. They love you. And you damn sure love them. It's a good thing. It's a good thing. That doesn't kill you. This will make your guys want to be as strong as this. It will. Don't get me wrong. Eventually was he did.
That's the truth.
They're gonna let you know how they feel about that. So it's they're gonna be on their way for their lives. Wonders. Whatever that journey is. There's no definite people. Just to say it. Never let you go. And, my lawyer would say, my friends just told me, so there's no problem. My lawyer is going to tell me, these are the things. This is not one. So I agree with what you're saying, and that's it. But my discretion, I will keep you upbeat. I will keep you upbeat. And let her know that. I know, it's on me, I got it. I said, I'm going to take care of her. She's the one who put me in my fucking ass. You know? But I'm telling you, that's what I'm saying. So I was saying that it was great. You found it. You can never come back and be in that position and get in this stuff you could possibly do. Because it's not that because you're never going to come back. So you must take advantage of everything. Enjoy because it's a one.
You hear someone singing in the background. I wonder if he's in the shower.
I feel you. I'm talking about don't make me crazy. That's what you know. So I said, that being told about your shit.
I don't know, because they're discussing it.
But you can't. But of course everyone else can.
Yeah,
So it's always a one-sided thing.
yeah, that's why, I know my heart, I know it. I can't talk to her.
This is the third full day that this woman has been on the stand.
So,
I can't hear you.
what's this? Yes.
I can't really talk to her about it right now.
No.
But I think she's probably the only one
Yeah.
that, everybody else, believes the worst, so. That's why it's really difficult.
But I would say this is. Yeah. Whatever. Take that one to the. Okay. Because after getting rid of all this, the rest of it's small shit. This thing, nothing else really done. The rest is good. Rest. The whole life has changed. So there, and I gotta do something. I gotta do something. So bad. So bad. No matter what the outcome is, good thing to do.
Won't be the end of that, please.
The transcripts are being collected.
Please be the end of that. No more recordings, please. Come on. No more. No más. Court TV people. Not the show, but us.
This
Give me
day
no more.
let's see, because I'm referring to their PP, sending through things through the PPs. What are the PPs?
Those are the inmates that act as sort of their pen pals to receive their mail and disperse it to
And
them.
pay them with commissary to get that done.
And
Thank you so much.
when we heard them discuss his estate and referring to the person with respect to probate as him, who is that individual?
It's his name.
Was there anyone that was going through a probate in this particular case based on your investigation other than the victim?
Yes. Oh, no, I'm sorry. The victim, it
The
was
surviving
his
Sementilli?
estate, correct.
All right.
I want to start a campaign.
The next transcript, it is approximately 6 minutes in length. This one is dated 11/2 of 17. And this one is identified as Exhibit 269.
Thank you.
We want Baker, not Broken Baker, but the other Baker. Oh, this woman, I got to tell you, she's earned her keep on this case. She has been on and off this stand for at least 3 full days worth of testimony,
All right.
at least. I don't know what's going on. I didn't stop that. Oh, we must be having a sidebar. I'm going, y'all. I see it. Okie dokie. Okay, sorry. Had some things pop up in Discord and was hoping it was some new stuff, but we are all good, y'all. I'm sorry about the microphone. I don't understand. You I I don't know why y'all can't understand when I talk. Hi, Crystal H. Welcome. Happy Tuesday, Haley Mouse. I apologize for that. I do have a guy who will be coming in the next couple of weeks. He is a tech, and hopefully he can figure all this out because you should be able to hear me over the sound. I don't know why you can't, but you should. So I will try to stop that. Happy day, everybody. Oh, happy day. Where did it go? Where did I go? There we go. You hear somebody coming back? Sidebar's over. We really need to get some other testimony in here besides this poor woman. She has been on like crazy. Yeah. Okay. I got you.
I look at the picture of the baby all the time. She looks like you. She does. Your sister told me she looks like you a lot. Yeah. I'm so, when they come to me, I'm so frazzled all the time. I was so worried about you that week. I was so worried. I want to go home. Yeah, well, it's going to be a while. It's going to be a long while. Depends on what was they're getting. I don't.
Sorry, guys. I wish we could get rid of these recordings. This is the worst part of trial. Hang in there. I got to get through it at some point.
Oh, no chance of that. Otherwise, But if you come in with a different, no issue. If you come in with a different, because you started that way.
So it's brand new. We're one last night, but that's gonna use my info. You'll see it, it's on the website, but can't use it now. So that's so work on it.
I want to try this,
Yeah,
because they do things.
yeah.
I'll ask them if I can do it to them.
Some of you.
Yeah, they'll call and do things.
If you, it can work, I just have to use it.
I just gotta pay them, so.
So, yeah, well, I'd say it's just, 1,000 people.
But I'll wait till you get all that stuff,
Yeah.
and then when I know we can do it, I'll mail you the,
Right.
but I can't tell my,
No,
or my,
Y'all, this is getting
their,
no.
to do this.
Oh, no, absolutely, no, absolutely, no. They're gonna be watching. Totally watching.
My, it's good.
I'm there now. I don't see him pop up. Let me refresh it.
Second.
I'm in it right now. I just answered you. I only have the two you sent earlier.
Oh,
Sorry. Toxic. I only have the two you sent earlier. I'm seeing that.
Look at, I'm gonna put your initial down.
usually stop.
Not live.
No, I saw that, and that's why I went back to you, I get a tattoo your initials.
I'm doing the same shit. Same shit. You're not one of my sister, man.
Yeah, what day is this on, Friday?
Say no.
I'll have it.
Okay, I'll try.
And the people are collecting the transcript.
Did you put them in the Karen Reed folder or live? Because I don't have anything. Nothing tip. I just sent you a response to your typed.
During the, this set of
Oh.
clips as well as one, the other day, we heard the defendant refer to someone by the name Deborah, and on a prior date, Baker referred to somebody as the busybody Debbie. Is there a Debbie or a Deborah in this case?
Yes, yes, it's Deborah Obad.
And when we heard
Don't know why I haven't gotten the
defendant
documents yet.
and Robert Baker talk about three-ways, what is that?
That's what we were talking about before, the three-way calling where Robert and Monica arranged to call in to a third person that would connect the calls together so that they could talk.
Love you, my bad.
In other words, calling through a third party.
Correct.
And when we heard clean one, is that calling through through a third party using someone else's inmate number?
Correct.
Rudder, we now have Exhibit 270, which is the last call or set of overhears from January 4th of 2018.
You mentioned this is approximately 31 minutes, is that correct?
Correct.
Yeah, this is fine.
Oh my Lord, y'all. We got some stuff to go through. we got a bunch of Karen Reed stuff we're going to go through on the breaks. Thank you. You are an amazing person. Thank you so much. We love you. Once again, As the Gavel Drops comes through again. She's amazing. Y'all got to go over there. Click on that. Yep. Can you drop your link for me? I'm trying to download these documents.
It could be the furthest away from me.
Of course, you know.
I can set it right here.
You know, routine.
Thank you.
Don't ask about today.
No,
I'll get a new one. I'll get a new one.
but what about all the other stuff?
Oh, he'll get there. He'll get there. He took Christmas time, so. 2 weeks. So everything's going forward.
Well,
Everything will get there.
okay.
Yeah, without the whole, everything else hold on.
Well, it's been daily, so,
Okay, well, as it stays.
Okay. okay. Hey,
I can see
oh, do you?
Yes.
No, it's getting busy in here.
What is that?
It's my toothbrush and toothpaste. How did you, accomplish that?
Yeah, come on. So,
What was the last, your hemp health?
20th, and it was on the 20th, I think it was the 20th, it was,
No.
let me see.
Huh?
Yeah.
Oh, yeah.
Okay, guys, you're going to want to stick with me because guess what? We got 8 documents to go through today, and it is getting hairy. I'm going to pre-read a little bit so I can read them better for you and it'd be clearer. Okay, but y'all, break is going to be fun. Better than court, that's for sure.
Like, I think I sent something to him even yesterday, so I hope they get it. That was probably the craziest one. And I didn't even want to write it. But I couldn't keep it from you, so.
It'll rise.
Are you sure?
Yeah, because he's only until 14 days.
Well, I hope so, because if you said the last is the 20th, and it's already the 4th.
Yeah, well, it's been holidays, so it's gonna be.
The last I got, my law was the 21st.
You and Luigi cool?
Yeah, but it's not gonna be the same as it was before.
Not really, I understand.
Yeah,
I don't know where that came from, that was weird.
it was really weird.
Your thoughts?
My thoughts are, getting down.
You should get a whole lot of stuff. Yeah. You get it?
I got up to, the 21st, I think.
Wow, so you get started 3-4 days.
Used to.
So yeah, what to say, the clean one I gave you, probably won't be, that's the same one to that same thing. Did you get that?
Clean one, no,
Clean one. Oh, wow, that didn't happen.
no.
Should have been already. That should have been already. I might be there anytime yet.
I got a body puffers. I'll be right back.
Sporadic.
I don't know, I think that, I think I need to get a new pen pal anyway, and you should too.
Well,
Just to see, you know.
say Pete.
last thing, she said, being said, yeah, wasn't, I hate having to censor every fucking thing I wanna say. Fuck. It is. Apparently, mine's been talking to yours a lot. Yeah. Yeah, so far, all good.
It's hard to get
I know. Oh, I had something else. But you wouldn't have known because it takes so long to get to you. But I had something here for you. I don't know if they'll let me pass it to you downstairs. No, I'm gonna tell them. They'll do it. I have a matching one on my ankle. So you have some mail, right? What? I can't even see. Okay, I need some just leave it for me, I'm sure. Is
Yes, you did, love. Miss June gifted you a membership, babe. Yes, thank you, June, for your gifted memberships. You guys, it's important for the life of these channels sometimes to receive these kind of gifts, and it is so greatly appreciated, and it's very humbling, and I very much thank you from the bottom of my heart, June. Welcome aboard, Miss Lady Jane. Yay!
oh my God, I have so much to tell you. Looked at yeah. We need to do that. Like we need to do that right away.
You're using, whatever, on the city.
No, it does because it doesn't matter. I just don't want to give them anything.
Oh, yeah. Here we go, y'all. Sorry about that. I don't know why we're bogging down, but we are. Maybe we have about 30. Double check it because you don't get one if you already joined. So maybe you're that. Yes, ma'am. Hang back there.
Okay, because if they do, they're gonna, eventually they're gonna. I just haven't said it. I wasn't asked either.
I'm not gonna say that.
I was asked on, the mail that I do get from you, I think I have 2 or 3 envelopes and pictures, you know,
That's it, not bad.
yeah, that's all I have, and so every time he comes to visit me, he wants to see them just to make sure, because they haven't seen them, so he wants to have the exact same, what they have. And, but I just, when he comes, I always forget, listen, there's nothing in it about the case, so. Well, look what they're doing. I know, I know, it is ridiculous. And someone is gonna pay for this. I know. Well, that's what they told you. That's what they told you. Yes, I know. I know all that already. Well, yeah, but even it's, you know, vice versa.
I know.
But it's no.
I told mine that.
I know exactly what you said. So it's all in.
Alright. Me too, and then, I told my people. Yeah. We'll push on shit.
No, that doesn't work.
But they know that already.
Okay, but no. I don't wanna hear that anymore.
I know, man, I know, but I'm saying, if I see it, I see it, it's gonna be on.
We are gonna go home and then they're gonna pay for this.
Don't panic, people. This is a Haley mouse. I can see that her computer must have crashed, I think. So she is missing at the moment and the stream's stopped. I'm just going to have a look and see If there's anything I can do, I don't think there is. Yeah, there's nothing I can do at the minute. I think that her computer's crashed. But don't worry, she'll be back in and she'll be up and running before we know it, I'm sure. Let me see if I can get some music on for you. Bear with me. Give you something to see on the screen. Or how about this one actually? Let's put this one up for fun because it's cute. And let's have a bit of funky music.
Thank you so much, Haley Mouse. You are freaking awesome. I found out that there is some glitching going on in StreamYard, and I have a tech thing sent in. I don't know why we're having problems, but we are still here, and you haven't missed a dang thing. I can tell you that. You've missed nothing of this trial so far. So here we go. Thank you, Haley Mouse. I love you, my dear friend. Love you. Hola, Elaine.
Yeah, you know how you know that,
Heck
what's the
happened.
name of it?
Instead of SHIT happened.
The Chico balls.
Sorry. Instead of SHIT happened, tech happened.
And it was so funny, but then yesterday's, I sent to my pen pal, oh my god, it was nasty. I don't know how I came up with that poetry. I cracked myself up. But it was good. It was good, so good that everybody copied it. Because my friend comes, goes to court with her husband. But I'm trying to, that's what I'm saying about minutes and stuff, I'm trying to cut down things that,
Sure.
the guy called everybody collect, so.
So we can, I put on this call, I think we just call us, tell you from right home. I think everything that she's calling is Saturday.
Yeah, that's what I thought.
You wanna do that?
Yeah, but that's what I thought, because then I was reading something that's, said, why is there no check-in or anything like that, and I thought it was Saturday.
Yeah, because this is good to know that,
Yeah,
you know what I mean?
yeah.
So, because the way I have studied existence is, and I think you might want to do it too, and I'll verify it, is the way I had it set up, if there's nothing, when I call her, and sometimes she didn't. So if it just doesn't go, that's cool, and if I want to relay a message to her, and then one more time, so if she said, call her, she goes, how did this? And then I said, she doesn't answer, unless it's on a day of, let's go things. So, like that, I'll cover that again, that day aside. That every system is used, then she I'll do this, I'll we'll still do all of it, but without the things that we made, it'll be quick, like, boom, all good, all fine.
Sure.
It'll be, boom, it was info. It'll be home at, so let's say I go, then you go to one, just check in, real quick, if there's something important, come back to me and say.
Okay.
It's good, I think it's good.
It's good, but still, again, like, I wanted to leave it because,
No, that's it, because you can still pass on the information that's needed on that Wednesday, or whatever day. If there's something important. We could. We can do that.
you do it.
Yeah, I enjoy it.
But, for me, like, hearing some things were really good, like, made me feel really good.
Yeah.
We're even there really starting to leave,
Yeah.
so it's good.
Who is you?
No, on my team,
Oh.
yeah. Okay.
Well, my.
Really? Yes, I think that's, I think it's changing, but I also think that it's being done without purpose.
No, what I'm saying is this. The feeling that I had. My son basically said this. The only thing they have allegedly is, and I was, that's it.
Well, that's why it's so ridiculous. Have you looked over it? Oh, I have, and I was laughing.
I'm thinking.
It's ridiculous. Yeah. Because I'm wearing short skirts and I'm being promiscuous. So that's, like, it's ridiculous. Yeah. No, they know. They know that. It's all stupid circumstantial stuff. I have. It's all, to me, it's all stupid waste of time. There's nothing, I don't know.
Let's see. I want to know what they're wrong about. I need to see. That's it. So far, what I have.
I don't know.
Yeah. I don't see how. I told mine.
Yeah.
And what I always do is the same shit.
It's just so, it's almost funny because it's just unbelievable.
Well,
Yeah.
that's all they
Yes. Yeah.
And I said one thing, I said, it makes no sense because worth more
Yeah.
than, that makes no sense.
I know. It's ridiculous.
And they want me.
Dang, y'all. I got you on, Boo. Toxic, I got you here. I'm looking. I've gotten them all. Thank you so much. Now I got to organize. Got it, Haley.
We're both gonna wait and then this minor will be over. Well, no, it won't be over because they. Okay, well, that's fine. To do that, you can't do that.
Are you guys struggling with this? I am on the border of saying screw this until this is done and we talk Karen Reed, because I think that's what we're going to do. I'm going to let this play. When I see we have a witness on the stand, we'll do it. We can't hear any of this. We just had like 20 docs just drop. So what we're going to do is we're going to talk Karen Reed while this is going on. My problem is I have a lot of documents and I'm trying to keep them in order if I can. So we're going to start off with document number 557 and we're going to go through, we're going to read, and I am going to just keep this going in the background because I know I'm not going to fight with all this. I'm not. Just give me a second. I'm trying to get things to line up. There's been a lot of boring evidence in this one, so we're moving on. Watching her in the background. I have her over here. Toxic. I have you up. Well, I can't do that. I got to have you up here. Well, I can do it this way. Do me a favor, Haley Mouse. I'm going to really need you for a moment. While I'm reading documents, keep an eye in the live chat. If you're able to see live chat communications, are you able to see live communications and as the gavel drops? If you are, keep an eye out. I've got documents all the way through. The last one is 577 point whatever. So we're going to switch. This is going to keep going. We are going to go to Karen Reed while this is happening. I am not trying to be mean, but I cannot listen to that another moment. I cannot. My brain cannot do it. It ain't gonna happen, y'all. So I'm gonna try and embiggen this and get this as embiggened as I legal. Whoa. Let me do it this way. Okay. And yes, this is going to catch all of the inaccuracies in the document, but that's okay. Okay, here we go. We are now in the Commonwealth of Massachusetts Superior Court. Motion for protective order. The Commonwealth respectfully moves in pursuant. Oh, good. This fits this way. To the. I got something popping up in front of me. Give me a second. This is irritating me. It's going to irritate me until it goes away. Hide. Thank you. Perfect. Respectfully moves in pursuant to Massachusetts Rule of Criminal Procedure 14A6 for the Honorable Low establish a extractive, whatever that is, order to restrict the public dissemination of all communications to provide the defendant on March 10th, 2025. detailed in the Commonwealth Notice of Discovery CL. This order is necessary to effectuate the well-established privacy and the safety interest of the witnesses and the victims' families. Furthermore, certain materials being provided as discovery should be in this case may be evident in an unrelated pending criminal case. What? What is the unrelated pending criminal case? Is that the Birchmore? Are we talking about Birchmore? Is that a possibility? The issue of protective order and the inherent authenticity of the issue of the what? Protective order serves as to y'all, this is driving me nuts. Unwaxed and tainted disclosure. Basically, they just don't want things to being disclosed as a practical matter to facilitate. Do you know what? I love this. Will it change it? Will it change it? Okay, well, it changed it. Is necessary for trial of the Commonwealth. Commonwealth agrees that this protective order is set without prejudice. Yay! Okay, nothing major there. This is, of course, Hank Brennan. Okay, Mr. Brennan. Now we're going to 558, the next document. Give it a second to do its little wheelie dilly thing. Takes a minute to think. Yes, please, y'all, go to as the gavel drops. Please, 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 please. Oh, why did that have to do that? I didn't tell you to do that. My computer has a mind of its own. So the motion for protective disorder is a no bueno. No big deal. Nobody's worried about that. I got to share this. I'm going to have to just put it over here. It's easier to read on the right side of me. So give me a minute. I can do this. I got all these windows up, y'all, and I'm trying to keep everything copacetic so it's easy for me to read and you guys to follow along. Here we go. That works. Share screen window. There we go. We're up and running. Da, 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 da. Enable editing. I'm doing that because if we still have enough issues with the spelling, so this is converted. Okay. Wunderbar. Now, the defendant's motion in limine to present demonstrative exhibit based on Christina Haley's testimony. Factual background, we already know what she's accused of. We already know what all that's happening on John O'Keefe. First trial, Christina, this is where we need to get to. Okay, January 29, 22, O'Keefe is captured on surveillance footage leaving the Waterfall Bar and Grill. We are in break in the Sementilli trial. Yay. That was Hanky. Haley, can you put a comment that we're on break? Oh, never mind. I'll just do it. Might be faster. Court break. And I'll just put that up like that. There we go. With a cocktail glass from the bar in his hand. The Commonwealth claims that this glass remained in Mr. O'Keefe's possession at the time he arrived at 34 Fairview Road and was broken in an early morning of January 29, 22, outside the Albert's residence. After being struck by the taillight of Miss Reed's vehicle, we're going to watch a video because somebody finally did what I wanted to. They got taillight and they broke it. And that glass is this thick, y'all. Anyway, back to this. Outside the Alberts residence after being struck by the taillight, Miss Reed's vehicle. Over the course of several searches, law enforcement recovered numerous pieces of glass from the yard outside of 34 Fairview Road and the rear bumper of Miss Reed's vehicle. The source of the glass recovered from the bumper of Miss Reed's vehicle and the lawn of 34 Fairview Road is material and relevant in this case. At the first trial, Christina Hanley, a forensic scientist for Massachusetts State PD or MSPCL, testified that the Commonwealth about the pieces of glass recovered from the crime scene from the bumper of Miss Reed's vehicle. This testimony, more than an hour and spanning 37 pages of trial transcript, ID. Throughout her extensive testimony, Ms. Hanley discussed 16 distinct pieces of or glass recovered from 34 Fairview Road and the bumper of Miss Reed's vehicle. These 16 pieces of glass originated from 4 separate sources. That's huge, y'all. 4 separate sources. Some pieces of glass came from the same source, meaning they were originally a part of the same object. ID at 7577. Miss Hanley's testimony is very intricate and difficult to follow without some sort of a visual aid. During trial, Miss Hanley herself frequently needed to refer to her notes and requested of counsel I lost my place. Frequently referred to her notes. Evidence of counsel repeat questions to keep the various pieces of evidence she was discussing clear. To remedy this problem, the defense proposes the use of a demonstrative containing representations of all recovered pieces of glass and graphics depicting which piece came from which source of glass. The proposed something Monty and report. The chalk starts by identifying, okay, do y'all know what a chalk is legally? I know what it is, but I'm going to pull it up just to give you the actual definition. So the legal term, that's not what I'm wanting. There it is. A chalk is a demonstrative evidence. So it's anything that is drawn, any sketches, any models referred to by a witness in aiding in their testimony. It is a physical demonstrative of their testimony. And I knew that. I just wanted to make sure I got the correct, make sure I don't give you some word that was wrong. So the word chalk is basically the actual evidence itself. I mean, the demonstrative itself to aid this witness keep up with what she's testifying to. Tracks directly with Miss Hanley's testimony, Hanley's testimony and report of the pieces of glass taken from the bumper of Miss Reed's car, viewed by laboratory as one item. 3 in parentheses, items 7 through 12, 9 pieces of glass taken from scene by Buchnick, viewed as one item at the laboratory. That's a no-no. If they're going to be viewing, they can't do that. Each individual piece is an individual piece. You can't. Okay, I'm sorry. I got distracted by. Do we have more? No, we're good. Okay. So I'm trying to keep up with all this information just flowing in. So what they're saying is there's 9 pieces of glass, but the laboratory reviewed it as one item. You can't do that. And number 4, items 7 through 14 as a single piece of glass taken from a scene by Trooper Proctor. What? Wait. Items 7 through 12, 9 pieces of glass taken from scene by Butnick. And then it says items 7 through 14, a single piece of glass taken from scene by Proctor. Who took it? Where did it come from? Hello? That doesn't make any sense. Does that make any sense to you guys? How in the hell can 2 people be finding the exact same pieces of glass? Okay. ID at 86. Each smaller piece of glass within an item 3-3 and 7 through 12 has an additional letter label referencing individual pieces itself within a broader item. ID'd 87 and 88. Items 3-3 contain a sub-label A, B, C, D, and E after each letter representing each individual piece of glass. The sub-labels are the same as those assigned by Miss Hanley in her testimony and her lab report. Similarly, 9 pieces of glass are items 7 through 12 are labeled A, B, D, C, E, F, G, H, I, J, K, L. No, it's actually A, B, C, D, E, F, I, K, and L. Skipped letters G and H was done by Miss Hanley in testimony and in her report. For each individual piece of glass, the chart includes a graphic next to the corresponding label based on which other pieces of glass and the piece matched. The graphics in the columns next to each label correspond directly with Miss Hanley's testimony. Particularly or whatever, the testimony on pages 75 and 76, 90 and through 92 on June 5th of 2024, trial transcript ID, blah, blah, blah. Each sublabel has a graphic next to it indicating which other pieces of glass it matches. Through these graphics, the chalk summarizer us. Okay. Haley's conclusion into the simple chart, which GI's Hanley confirms was an accurate representation of her testimony. Argument. To assist the jury in visualizing Miss Hanley granular and blank essential testimony, the defense proposes the attached demonstrative exhibit or chalk to the jury, which is attached here as Exhibit A. Demonstrative exhibit is something presented to the jury to help them better follow and understand the evidence, but is not evidence itself. Demonstrative exhibit can be taken in many forms, including live demonstrations, charts, and even literal chalk figures on a blackboard. Yes, it can. Commonwealth versus Walter. Demonstratives are particularly useful when a party presents a complicated testimony that may be difficult for a jury to understand or visualize. The Commonwealth versus Mimless allowed the use of 34-page bar charts as a chalk to depict hours defendant billed to Medicare for a particular period. These sorts of aids are appropriate where 1, they are relevant. 2, they're not more prejudicial, than probative. And 3, they are sufficiently resemble the actual event so as to be fair and impartial, or they are fair representation of fact or chalk. Got another one, folks. 82 goes there. I am keeping a very good flow chart of this. So they are representative of the facts and chalk aims so to clarify. My gosh, y'all, it's still coming in. Oh, I can't do that. Delete. I need to click on it first. This is when it would be nice to have an in-house person or someone who has access to my computer. Braxton! Y'all don't know who Braxton was. He is a famous guy on our channel. He was my computer dude till he started working, and then he just got too busy. Finally, the court has broad discretion in determining whether to admit a demonstrative Commonwealth versus Walter 10. The proposed chalk is highly relevant. Should be relevant. Miss Hanley's testimony is clearly relevant. Whether any of the glass on the bumper matches a cocktail glass at the scene or is from some different unidentified source, and goes directly to whether the evidence in this case supports Miss Reed's struck John O'Keefe or the cocktail glass in question. Relations between the other pieces of glasses are critical to understand the scene. Therefore, the chalk, which summarizes summarizes Miss Hanley's testimony about the glass, is also highly relevant, especially given the chalk provides more needed clarity on otherwise complicated issue. How much more of this do we got? Oh my gosh, y'all, we got a lot. Without the chalk, the jury would need to be able to enter accuracy record or memorize the source of each piece of glass and each piece relationship to another piece in order to make sense of Miss Hanley's testimony. The complexity of this testimony is understood by Miss Hanley, frequently refers to her notes requesting for counsel to repeat questions, particularly questions about the relationship between the pieces of glass. 26 RT at 75, 89, 95. Of course, referencing notes and requesting a representation of questions, repetition of questions is permissible and even preferable to ensure the testimony is accurate. However, if the lab experts have trouble keeping up with the labels of evidence that she analyzed herself, surely the jury would have even more of a trouble making sense of the critical evidence, making the chalk not only relevant but essential. I did see that. Thank you. Oh my gosh, I know. We've had nothing and we have nothing. And then now we have everything. And while this trial's on break and you can't understand a thing they're doing, we're going to be on this for a little bit. When they actually put a witness on the stand, we'll go back. Number 11. I hope this is getting to the end. We're halfway through. Number 11. Chalk would not be prejudiced the Commonwealth. Any prejudice that it may be argued to this from the chalk so is something outweighed by its probative value. The chalk does not prejudges, I can't say this, prejudice the Commonwealth in any way. Rather, the proposed chalk would be highly probative in relation to Miss Hanley's testimony, which would be otherwise something jurors to memorize and differentiate the titles. I'm reading because I lost my place. Miss Hanley's system, which otherwise blank jurors to memorize and differentiate the titles and sources of various pieces of glass, which labels that closely resembles one another. It merely is a depiction of what glass pieces match others and a visual representation of of Mrs. Henley's life testimony. Commonwealth versus Mims, blah blah blah. Given that the chalk corresponds so closely with Miss Henley's testimony, the witness for the Commonwealth is too difficult to see how the chalk could be remotely prejudicial. Thank you. Even if the court finds that there are some prejudicial tendencies to the proposed far outweigh the probative value, the Supreme Judicial Court of Massachusetts has been liberal in allowing demonstrations and chalks, even where there is potential for extreme prejudice. The Commonwealth of versus Mr. McGee, where the defendant was accused of blank murdering his partner in front of their 6-year-old child. Ugh. The Supreme Judicial Court of Massachusetts upheld the allowance of physical demonstratives by that child, then 10 years old, of the position in which he saw his mother on the couch when she was unalived. ... In support of the decision, the court highlighted the testimony about the defendant's position on the couch at the time of her red room was crucial in determining whether the predetermination elements of the red room in the first degree was met. Given that a live demonstration by a child of the position of his mother when she was unalived was permitted. We have a witness out of order. I'm going to keep the volume up. Oh, 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 y'all, we may have something good.
Record, say, spell your first and last name, please.
It's James Fillmore. James, common spelling. Fillmore, Fillmore.
I'll pick this up
Your Honor.
where we left off.
Mr. Fillmore, what was your occupation on
Thank you so much.
January 26th, 2017
I was a detective.
for
I was working with the
what agency? I'm sorry.
LAPD
Thank you. Go on.
in a Valley Bureau homicide unit.
And at that time, how long had you been a police officer?
It's 2017. That would have been like 16 years, 16, 17 years, something like that.
And how long did you remain a police officer?
20.
Till 2020?
No, 22.
And
20,
You retired out.
23.
You retired at that time?
I was terminated.
Oh,
Going back
Terminated.
to the date of January 26, 2017, what was your assignment on that day?
I was in the Valley Bureau homicide unit.
And were you familiar with the investigation
Not
into
good.
the death of Fabio Sementilli?
Yes.
Who was in charge of the investigation for robbery homicide at that time, if you remember?
When I was involved in the case, robbery homicide wasn't involved. I was with the initial team. The lead investigator at that time was Gene Parshall, who's no longer with us. Rest in peace.
Yes. And that was out of the San Fernando Valley, is that right?
Yes.
Okay. And what role, if any, did you play in that investigation?
I was involved with I was in the squad that was called to the scene. It was our call, and so I was at the scene.
So you were at the scene of the murder
Yes, sir.
on the day it occurred or some other time?
I don't remember when it actually occurred. It was determined to be occurred, but I was the first group of detectives at the scene.
And did you remain assigned to that case for some period of time?
Yes, until it was passed to robbery homicide.
Okay. And how long was that?
I couldn't give you an exact time.
A few.
It wasn't long.
Okay. You're aware that the decedent, Mr. Sementilli, had an autopsy, of course, correct?
Yes,
Did you play any role in that autopsy?
I went to the autopsy.
Okay. And if the date I have of the autopsy appears to be January 26, 2017, does that sound right?
I can't remember the exact date.
Okay.
But,
For what reason did you attend the autopsy?
I was assigned to go there with my partner at that time, was Detective, now retired, Robert Plerdy. And we were there to help out the lead investigator, to give him some idea of the cause of death, things of that nature. During the preliminary phase of the investigation, to help out the lead investigator on the case.
Is that because this was a criminal investigation as opposed to just a natural death?
Correct.
Okay. And you said that was Detective Parshall?
It was Plerdy.
No, I mean Parshall was your supervisor at that
Yes,
time?
Your Honor, that misstates the evidence.
So, what's your question? I'm sorry, sir.
I thought you said you were working under Detective Parshall at that time?
Detective Parshall was the lead investigator. I went to the autopsy with Detective Plerdy.
Sure. And were you assigned to go there by Detective Parshall or someone else?
Yes.
Okay. Had you ever attended an autopsy before for that same reason or purpose?
Yes, I had.
And about how many autopsies had you attended before that day?
Maybe 24.
Did you have any background or training in medicine or autopsies, coroner office, anything of that nature that prepared you to attend those autopsies and this one?
I'd never received any medical training. I'd been around a lot of murder cases and things of that nature to be able to identify, injuries or wounds, things of that nature.
I assume you went through the normal training of the police academy before you became a peace officer. Is that correct?
That's correct.
And I don't know if I asked you this, how many years were you a peace officer as of January 2017?
That would have been 16 or 17 years.
Okay. So you go to the autopsy and your role there is what again?
To get any preliminary information from the coroner investigator or the doctor about things such as cause of death, how many wounds, maybe what kind of wounds, anything to help out the lead investigator during the preliminary phase of the investigation.
To help solve the question of who committed the crime.
Yes, sir.
Okay. And when you complete that, you attended the entire autopsy, is that right?
Not the entire, just the initial phase of it.
Well, you remember the doctor's name?
I don't remember, no.
Does Dr. Ukpo, UKPO, ring a bell?
I couldn't tell you. I don't remember.
I take it you attended autopsies conducted by different coroners, is that correct? Or working for the coroner's office at that time?
Yes, sir. Yeah, there's quite a few.
Okay. So do you remember at all the Sementilli case?
I remember the case, yes. I don't remember specifically that autopsy, but I remember the basics of the case, yes.
Okay. So you and Detective Plerdy were present during the autopsy, obtaining information that would be helpful to the investigation, correct?
Trying to do that, yes.
And how do you do that?
We'll ask the doctor doing the autopsy what he sees, things of that nature. Sometimes it helps, to know what kind of, in his opinion, what weapon was used, things of that nature. So just looking for any kind of any information to relay back to the lead investigator on the case.
And I assume in this case, as in others, the medical examiner performing the autopsy was cooperative with you?
Yes.
And how do you record what he tells you that you believe is of any significance?
The way I would do it is I would write handwritten notes, and then I'd take it back to those handwritten notes back to a station, and type them out so they're more readable, and then give them to the lead investigator.
Roger, is this been marked? If not, could I have marked as next in order? Autopsy exam document.
One moment. Question you have is, has it been marked? And that's what I'm concerned about. All right.
Okay, so I'm trying to look at documents. We got to we've already read the protective order. I'm trying to organize all these, y'all, because I'm getting documents like crazy. 5. Sorry, guys. This is a lot, y'all. Y'all have no idea how much just dumped into my lap. A lot has just dumped into my lap. So, patience, please. Uh, 72, that's 57, 8.
Proceed, please.
A lot.
I'm going to show the witness what's been marked as Exhibit 621.
I'm gonna object the foundation at this point.
You can show it to the witness. It's over.
Mr. Fulmer, would you take a look at this item that's been marked as Exhibit 621? Read it over to yourself and let me know when you're finished.
Okay.
Is that your name and the name of Detective Plourde, Plourde, at the top?
That is my name. I don't,
Well, let me,
yeah, that's my name, yeah.
and did you place your name there?
I don't know. I don't believe I wrote that document. It's not the how I wrote it, and I always sign my documents. So I think that was Detective Plourde that did that.
Okay. And did you participate with him in preparing that document?
Yes, sir.
And would this document record, to the best of your ability, the information that you were provided by the medical examiner?
Yes.
And is it prepared in the normal course of your duties as a police officer?
Yes.
And was it accurate at the time, as far as you know, to the best of your knowledge, at the time it was prepared?
Yes.
Can you tell us, looking at the report, what the doctor indicated to you was the number of stab wounds?
Can I read it?
If it refreshes your memory.
I mean,
Yeah, he's been checked out for a while since he's been no longer a part of the PD because, well, he was
7
fired.
total stab wounds.
Again,
Or
I'm
like-
gonna object to the witness reading from the document.
Sustained.
Move to strike.
Okay.
Thank you.
But this does record what you and your partner prepared at the time that the autopsy occurred or shortly thereafter. Is that correct?
That's correct. And I just told us to add, sometimes,
What? Similar?
this
I'll be
is
right back.
preliminary,
Be
so
alerted.
sometimes we would leave before the autopsy is completed, and sometimes they'd find more after we left. But that document's, while we were there, the best that we saw or got from the doctor.
And obtained from the doctor.
Correct.
Did you have any more contact with the doctor after you prepared the report?
I did not.
What did you do with the report after it was prepared?
Again, I don't believe I authored that document there, but I can tell you what I would, if it was my document, would do.
Well, do you know what Detective
He didn't say anything yet.
Detective Flirty did with the report?
I don't personally know. As an investigator, if I was the lead, it'd go in the murder book.
Well, your role and his role was to provide this information to investigator or Detective Parshall, correct? Is that correct?
It would have gone to Detective Parshall, and what he did with it, I don't know, but
And gone to him in the normal course of business?
yes.
What you do with all the autopsy reports that you participated?
Yes, sir.
All right, I have nothing further.
Community cross,
I would ask that the document be admitted into evidence.
that'll be denied. Community clearance,
Just briefly, did you review any reports, Detective, prior to coming to court today?
No.
Did you have any conversations with defense counsel before coming to court today or testifying?
Briefly.
Can you tell us about that conversation, please?
He just told me what I was here for, basically.
Being what? To talk about?
This autopsy that I attended.
Okay. Do you have any independent recollection of attending the autopsy?
Very vague.
And you said you might have handled or been present for approximately 24 autopsies?
Yes,
And you said you don't have any medical training.
I do not.
And you didn't, when you were asked about attending the police academy, there's no medical training portion at the police academy, is there?
I think it was a CPR class.
Okay. But nothing in terms of recognizing wounds or patterns or tool marks caused by weapons or things of that nature? That would be within the province of the experts at the crime lab or the coroner's department, correct?
I mean, we get a little bit of that training in the field, but not very much in the academy.
Not on the level of the chief medical examiner of LA County.
No.
Okay. And you said you think you attended a portion of the autopsy. What portion? If you have any recollection.
Well, it would have been, it's the initial phase. So the initial phase that they're looking at wounds and things like that. I would never stay for the entire thing where the entire body is looked at.
Okay. So maybe prior to the autopsy when photographs are taken or?
Just prior to the point where the doctor is getting into the body to look at wounds and things of that nature.
Okay, so you wouldn't have been present when he autopsied any of the wounds to look underneath the skin to see any of the wound paths or markings, tool marks, patterns. You wouldn't have been there for any of that.
Maybe for a little bit, but not for the entire thing, no.
Okay. And would you agree that whatever the chief medical examiner testified to and included in his autopsy report would be more accurate than anything that you might have interpreted, thought,
blessing.
wrote down in
Thank
notes,
you
then
so very,
transferred
very
from
much.
notes
I
into
appreciate
some typewritten report?
Thank you. You just paid the electric bill for half a day.
it's overruled.
True.
100%. The doctor's report is way more reliable than my notes or Clardy's notes.
Okay, because you're detectives. Your job is to
My cords are all messed
investigate
up.
a crime, in this case, a homicide, and his job is to deal with cause of death and all of that, all of the features relevant to that determination.
Yes, correct. We're just trying to give him some preliminary leads, something that he can go on.
In other words, for you to be able to come back and say to Detective Parshall,
Cause of death is multiple stab wounds.
That's correct, as opposed to a gunshot wound or something like that.
Got you. Thank you. I have nothing further. Thank you so much. Appreciate your time.
Any redirect?
Yes, Your Honor. You don't perform the autopsy, do you?
No,
I'm gonna object, sorry.
Nope.
It's over.
The information you got for your report, or the one prepared by Detective Flirty, all came from information provided by the doctor, correct?
yes, I mean, we're there, we can see with our own eyes, but yes, it's majority from the doctor.
And what you wrote in here, like I asked you about 7 stab wounds, that came from the doctor, is that correct?
States the evidence.
Sustained. Not write anything in there.
This document was prepared by Detective Flirty in the normal course of business, correct?
I believe it was Clarity, like I said, because I would always sign my documents afterwards that I'd give to the lead investigator. That one's not signed. I believe that was done by Clarity. But I was there with him.
Did you review it?
I just reviewed it right here, yes.
No, did you review it before it was turned over to Detective Parshall?
Yes, sir.
And was it accurate as far as to the best of your ability at that time?
Yes, sir.
If it was not, you would have changed it or in any way gone back and got additional information from the coroner, is that correct?
Or tell Detective Clarity that didn't look right, you need to change it.
So if this was turned over to Detective Parshall, then it was accurate to the best of your ability, correct?
I'm
Yes.
fixing some.
And again, prepared in the normal course of business.
Yes, sir.
Got it working.
Was one of the things that Detective Parshall interested in is where the stab wounds occurred?
I'm gonna object, calls for speculation.
Sustained.
Did this report record where the stab wounds occurred?
Objection irrelevant.
Sustained.
Did this report record what the coroner told you in the presence of Detective Flirty where the stab wounds occurred?
I'm gonna object, again irrelevant.
I'll allow this.
Again, we get some information from the doctor and we could also see with our own eyes.
I want you to take a look at this sentence here, which is the 4th from the bottom, beginning with doctor. Do you see that?
I see that line, yes.
Is that what the doctor told you?
I can't remember what the doctor told us, but if it's documented on there, then yes, that would have been from the doctor.
Does it indicate this is what the doctor stated?
Object
Is that right?
to count, to reading from the report.
He hasn't done that yet.
Does this indicate what the doctor stated?
That's what it says, yes, sir.
And what the doctor stated was recorded by you and or Detective Flirty, again, during the normal course of business as your job on the date of this autopsy, correct?
Again, I'm gonna object, and this states the evidence, he said he didn't write this report.
It's over.
That's what you were there for,
Yes,
to record what the doctor told you to assist in the investigation, correct?
yes, sir.
And did he tell you the wounds were consistent with one-sided edged weapon
You
without
now
a
reading from
serrated
the report.
edge?
We've
Sustained.
had this conversation several.
Excuse me. Sustained.
Did he tell you what the wounds were consistent with in terms of the type of weapon used?
I'm just going to read through the.
Just to yourself now, don't answer what it says. Is that what was recorded here as your job and that of Detective Flirty?
No, that's 2 different questions, counsel.
Is that what is recorded here?
What the doctor said?
Yes.
Yes.
And one of the things that you and Detective Flirty were interested in this case was the type of weapon that was used that you could report back to Detective Parshall, correct?
Yes.
And did you accurately or Detective Flirty record what the doctor told you about that weapon?
To the best of our knowledge, yes.
And did he tell you that it was a one-sided edge weapon without a serrated edge?
Sustained.
He's talking. Shut up.
Did
Let
you
her
accurately
do her
record what he told you about the type of weapon? Does this report accurately, to your knowledge, record that information?
Sustained.
Let me ask you this. Were you
Yeah, let me get you some food.
involved at all in the Sementilli investigation following the preparation of this report and following, well, I'll start with following the autopsy?
I was involved in the investigation up until it was passed on to Robbery Homicide Division.
And you were involved when this report was provided to Detective Parshall, correct?
Yes.
And one of the things Detective Parshall was interested in is whether or not what type of weapon was used to kill the victim in this case, correct?
Sustained, and there's, let me see a sidebar.
Ooh, sidebar. Somebody got a sidebar. Uh-oh, ruh-roh. 91 and 93, got those, okay. I'm trying to keep up with all the documents that are dropping because we got some document droppage going on around here, y'all. So, yep. Yepers. Also, guys, I want to give a big mod love. Look at that. There's a mod love. If you become a member of our channel at any level, there are special emojis that can be used that I created. And, oh, I got to look. We had to be 13. I was waiting for the membership to go to a certain level because once it goes to a certain level, I can start making more special emojis. I love making emojis now that I learned how to do it. Real quick, the last part of this thing while they're in sidebar. The proposed chalk directly inverts to Mrs. Henley's testimony fairly and accurately, as described in the above detail, or as described in detailed above. The four categories displayed, the chalk and labels, use of the chalk, and the connections between each piece of glass are all drawn directly from Miss Henley's testimony. In fact, during the first trial, Miss Henley was shown this exact chalk, which she confirmed on the record was accurate, reflecting her testimony. Blah, 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 blah. We are done with that one document. Now let's back over here. You guys, it's my channel's first birthday. Whoop, 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 whoop. It was the first time that I put any video in. Now, my official, true 100%, I celebrate from the day to monetization. That to me is when I became an official commentator. Will be later. But we have been doing this for a year. And thank you so much for being along on the journey. My birthday month and my YouTube birthday month all in the same time. Isn't that wonderful? Isn't that wonderful? Beautiful and glorious in my beautiful boots. Oh, sorry. I got a CC whining going out in my head. What you talking about? That's my king. I love me some CC whining.
I'm sorry?
Just a few more questions, okay? Did Detective Parshall ever talk to you about this?
2 more members, and we add 13 emojis. Come on, y'all. We can do it.
Not that I remember, no.
And you said the new investigator who took over after Detective Parshall's untimely death was who?
It was passed, the case was passed to robbery homicide division. I don't remember who the lead was with,
Would Gable or Tellis, those names ring a bell?
yes, they do.
You remained working on the case under them as the replacements for Detective Parshall?
No, once it was given to RHD, they took it. That was their case at that point.
Did
You
you have
would
any,
help them with anything that they needed, you know.
did you have any other role in participating in the investigation, particularly involving the type of weapon that may or may not have been used to kill the victim?
The only thing other additional that I think I did is wrote a search warrant.
Okay. And do you recall if the information that you obtained, or Detective Flirty and your company obtained from the doctor at the autopsy, was included in the search warrant?
Say that again, sir.
Do you recall whether the information contained in this report that I showed you was contained in the affidavit for the search warrant?
That autopsy report had nothing to do with the search warrant.
I specifically just meant the item that you identified as being written by Detective Flirty after the autopsy. Was that included, that information, in the affidavit or the search warrant?
I guess I don't understand your question. I'm sorry.
The information you have on this report, you understand that?
Yeah.
Okay. Subsequent to that, you said you participated in the writing of a search warrant. Is that correct?
Yes.
Was one of the things that the search warrant was seeking the weapon that was possibly used in the commission of the crime?
Yes.
And was the information contained in this document contained in the search warrant to the best of your recollection?
Well, the search warrant was written before this happened.
Okay. You recall what the search warrant was written for? That is, the search of what or whom?
Your Honor, I object, it's irrelevant.
Gerald, it was even said that somehow at some point that some of the glass fragments did not match in any way, shape, or form to others, and they never served a search warrant on the home of the Alberts, and they had cocktail glasses in that house. Man, they were heavy drinkers, and they never. And it's just crazy. And you're right. The source still doesn't prove it's the same glass, because if you buy it in a batch, say you buy 100 of them the same time, they're going to be probably made about the same time. So they could be sourced the same time. You're right. Doesn't mean you're so right. I like the way your mind thinks.
Sustained.
Thanks for being on my channel.
Right. I have nothing further on.
Anything further by the people?
What council showed you, that's not a LAPD report, correct?
No, correct.
An LAPD report is written on LAPD letterhead. It has a DR number, and there are various details that are required to be included in an LAPD report, correct?
Correct. These are notes. These are notes that are typed from handwritten notes.
Thank you. I don't know.
Anything further?
Yes. What do you call this document then?
Autopsy notes. That's what I call mine.
And you follow the same procedure you did in all the other offices, right?
I'm gonna object. Dave?
Of course you are.
It's assumed as a fact, not as evidence. Again, this detective stated that he did not offer it, so he didn't follow any procedure.
Thank you. I have nothing further.
Yeah, you better not.
No, but thank you.
Thank you, Detective Gilmore.
Thank you.
You're gonna have Detective Roberts take the stand.
So I wonder if, back to the commercial of the jail cell calls that nobody can understand. Back to the transcript, guys. If they go back, thank you, Gerald. If they go back to that kind of testimony, we're going back.
Celebrate extraction report for Robert Baker's Samsung S8 item number 121. It's one page. May it be marked, please, as People's 271.
Yes.
Yeah, I agree with that, Haley Now. I like his way of thinking.
Detective showing you what's been marked as People's Exhibit 271.
You never know who's listening.
Top of this document reads celebrate creation time 11/28 of 2016 at 2:16 in the morning, which would be California time. And this is for a Google Android. Do you know what this document reflects?
Yes.
No foundation.
Overruled.
And what is that?
That is an extraction from Robert Baker's cell phone, his Samsung cell phone, and he is creating a lifestyle lounge account.
Yeah,
Did
exactly.
you also review information or what's referred to as an imaged file from the defendant's computer, that being an HP desktop that was in the second floor of the Sementilli residence that was booked as item number 88?
I did.
And was there information on that computer that pertained to things such as Bike Week in Myrtle Beach?
Yes.
Did it also?
I'm going to object to a motion to strike. There's no foundation, there's no report, and nothing to indicate this has the ability to make those conclusions.
Are you done with your speaking objection?
Ooh,
Have we talked about this before?
We have, and I'm trying to figure out the exact words to use for the exact.
Overruled.
oh,
Again, in reviewing the image file,
snap.
you caused that computer as well as various electronic devices to be reprocessed throughout the time that you handled the case, correct?
That's correct.
What is the point of reprocessing various devices once they've been processed the first time?
It's to use the newest technology in order to extract additional information that may not have been captured on the first try at processing the item. And a lot of times we'll get items that were previously deleted or didn't show up in the first capture.
So in other words, as you use newer software programs or updated programs, you're able to perhaps find more data in what's referred to as the unallocated space on the devices, correct?
Correct.
Areas where items have been deleted, but maybe not yet written over.
Correct.
And in each of these cases, were reports written for the prosecution and the defense with respect to the actual processing of all of these devices?
Yes, they were.
And with respect to, again, HP desktop item number 88, was there also various searches for queries through the computer for life insurance paid when a person who has a life insurance policy is murdered, in cases of murder?
Your Honor, no objection. This would be based on hearsay,
It's overruled.
no foundation.
Again, it's overruled.
Yes.
And was some of those searches, were those occurring on May 21st of 2017 after Mr. Sementilli's murder?
That's correct.
Were there also various searches on February 12th of 2017 for secured online solutions for transferring large volumes of encrypted or sensitive data.
There was.
And was there also, even as late as June 4th of 2017, searches for lifestyle lounge and the chat feature, member chat ID information?
Yes.
I have nothing further.
Mayor Cross.
Detective, first of all, welcome back.
Thank you.
Feel like before I'm done, I will question every robbery homicide detective in the LAPD.
Your Honor, again, I'm going to object to counsel testifying.
That was not meant in bad faith. It's all right.
Did you perform the examination of the item that you just referenced, which was what, a laptop computer, did you say?
It was a desktop computer.
Desktop.
I did not extract the information, but I did look at the results from that extraction.
And who did the extraction?
I believe the first time around it was Detective George Diaz. And the second time around, I want to say his first name was David. It was a detective. I can't recall his last name at this point.
Are they still active detectives or officers in the Los Angeles Police Department?
I believe they both have retired.
And were you present when they conducted their examinations?
Not the extraction. It's a process, from my understanding, that takes a considerable amount of time, but I did drop off all the information to them. They pick up the item from our property division, and then when the download is ready, I pick up the hard drive.
Okay, and so basically they gave you the results.
Yes, they did.
And this was with new technology, you said?
Yes.
And obviously, I won't say obviously, but your background and training is not in this field of examination. You would not have been able to do this examination yourself.
I would not be able to do the extraction.
But you could read it. They gave you the results, and then that's what you're relating here today. That's right.
Correct. The results in their accompanied report.
And is the computer still available to be examined as it was back then? You know?
I believe so. There's no reason that it shouldn't be.
Could be approached, sure.
Sidebar. They should not be asking that particular question. Is it still available to be examined now? If you were concerned about that, you would have already done that investigation. You would have already done that examination. So I don't understand. Misa Nosa understands. And if anybody is a Star Wars fan, you know who I just imitated. Misa no nada. Oh, Lord, have mercy. Oops, I thought I sent it. I tell you what, I love this beading, but seed beads get really hard on the eyes after a short while. I've got so much to do, y'all. I got 4 projects I got to complete in the next couple of months. Oh, me's a Jaja Binks. Me's a Jaja Binks. Jaja Binks was my favorite character. I just love me, Miss Jaja Binks. Oh yes, we liked him. Although he was a little troublemaker, we liked him. Mr. Jaja Binks. Okay. We have a new document up. When they go take their lunch break, we'll be reading that. I will be reading documents probably all through the night. We will shut this live down and we will pick up wherever we left off on documents and continue to read them tonight. I think we got like 11. Some of them are short, some of them are long. So we're going to do a document read tonight. Since I have nothing else to do. Not like I don't have a date or anything to go on. You're my date. Oh, my date. Y'all, my date for tonight. We will be doing Karen Reed tonight. And I think that's important. We need to get that done because I have a feeling tomorrow we're going to have even more. Vatican. Well, no, that's not what I clicked on. Just so you know, the Vatican offers another update on Pope Francis's health. It's been a difficult few weeks for Pope Francis and his faithful following, including parishioners, have been praying for him following being hospitalized with an infection. Now the Vatican has released an update, no longer in immediate danger. He is recovering. According to the report from the Vatican released on Monday, March 10, doctors have moved to lift the Pope's prognosis for the first time since he was hospitalized because he is improving. However, they state his condition remains complex and he is not fully out of the woods, according to the source. Well, I'll be honest with you, anybody at that age, just going to sleep and waking up is not out of the woods. Any of us can go to sleep and not wake up. So the Vatican source also said there's no timeline for Pope Francis to be released from the hospital, and he is getting treated with oxygen therapy as he is getting over the past few days. Making sure I had sound up. The Vatican added that the Pope was able to partake in a certain spiritual exercise remotely in honor of Lent. They stated that he has received the Eucharist and went to chapel at the hospital for prayer. Probably wheeled into. He was definitely wheeled into the chapel for prayer. Lent is a 40-day season of prayer, fasting, and almsgiving, and beginning on Ash Wednesday, which was this past Wednesday, ends at the sundown of the Holy Thursday, according to the United States Conference of Catholic Bishops. Okay, so that's good news. Oh, there's more. There were signs of Pope Francis' improvement over the weekend when the Vatican source shared that Pope Francis, I don't know why they put Pope Francis and then they say Francis, was responding well to treatment for the first time since entering into the hospital. The source said that Pope Francis was showing a good response to therapy and gradual slight improvements since experiencing acute respiratory failure. Pope Francis also released a pre-recorded audio message on Thursday, March 6th, thanking his supporters for their support and prayers. That's the end of it. I'm not Catholic, but I know how important he is to the Catholics and his parishioners, and I pray for healing and God's will be done. One crew member missing after U.S. tanker hits a container ship in the North Seas. By the way, did y'all know that we have trending 1970s haircuts that are coming back with the millennials and the Gen Zs? Yes, I know. I switched the camera angle for a change. You guys can see. Hey. See all my stuff? As you can't see the other monitor up there. I have 4 screens. Well, if you include the iPad, that's 5. Include the cell phone, that's 6. I got it all going. Come on, it's a stretch break. Let's stretch. Let's dance. Come on. I don't dance. This girl's not a dancer, but I'll wiggle. I have not had a bun this big in ages, y'all. Are y'all waking up now? Yay. Well, let me see. What is this one? This is kind of good for should I use this, y'all, for the what is it called? Sidebar music. Yep, that be sidebar music. Are y'all hearing any of this? Let me know, because I had the sound finally working.
Happy birthday.
Okay, we don't want that. Yay! Okay. We's all good. Wonderful. They're coming back now. Be right back.
When you're ready. Take it.
Thank you, Your Honor. All right, Detective Roberts, you were present the last several days while these overhears were being played to the jury. Is that correct?
Correct.
And your role in obtaining those overhears was what?
Well, I didn't really have a role in obtaining them because they were obtained prior to me being assigned to the case.
Do you know how they were obtained?
I spoke to Detective Gable and Tellis on occasion, and they basically, when the defendants were scheduled to appear in various court hearings, they were placed in cells near or next to each other, and the cells were recorded.
Okay, and that took place in the lockups at the various courthouses, is that correct?
That's my understanding, yes.
Were they placed there intentionally so that the recordings could be made of their conversations?
Yes.
So, as I think you said, only in certain cases do you go to, or do the detectives go through that procedure in order to obtain, they believe, communications between the two parties. Is that correct?
I don't know that I testified to that, but
I thought you said only in certain cases is this conduct or form of investigation conducted, and where you listen to the interchanges, if any, between inmates in the county jail.
Testimony, counsel.
I believe that was Detective Farrell.
Oh, fine. Okay, he's right here. If I could ask him.
I need to get a cracking whip
All right.
sound.
So you
When
don't
the
listen
judge
to
corrects somebody.
the results
We got a
of
crack whip.
those recordings, I take it, in mass, in determining which ones to select or play or so forth, do you?
I listened to every recording of the overhears
baby.
multiple times.
So everyone is much more than the ones we've heard in this case, correct?
Well, those recordings were tailored for this. They were cut down for this hearing. There's a lot of stuff that we did not hear in those recordings.
Tailored down by who?
I believe the prosecution.
Okay. So the raw material, which is every recording that is captured, is turned over to the prosecution, and they then determine which ones they will ask to be introduced into evidence or played to the jury, correct?
That's not
And
correct.
you can object over.
Let me give the jury their lunch break.
Again.
One moment, I'm talking. We're going to adjourn for lunch as far as you're concerned. Until 1:30, that mission applies. I'll discuss this case among yourselves, with anyone else, or former expressing an opinion until the cause is when I submit it to you. Have a good lunch. I'll see you at 1:30.
The judge is not happy. Something's going on. He said, as far as they're concerned, meaning you and I have a conversation coming up, babe. And the questioning and the way he's asking those questions to me is very misleading. And in all honesty, the prosecution at any time could have objected to those recordings, and they could submit whatever they want. So I feel his questioning was quite misleading. I just got to get one more bead in place. I need to anchor this real quick, and then we'll go into the Sarah. God, Sarah Boone's been on my mind, to the Karen Reed trial. Okay. And the moment I say that, of course, it's going to give me heck, and I can't do it. Come on, get in there. Quit moving. This is not easy to do. This beadwork is hard. I like a challenge, though. I like a crafting challenge. See, I have not been getting this done. Usually, if I really work hard, I can get one done a day, as far as just the backdrop, not all of it, just the backdrop. But that's literally sitting down for 8 hours a day, doing nothing but beading. So, okay, got that anchored. Now I'm not going to lose it. Let me put it there. Pope Francis has been a wonderful Pope, Ada. He really concerned about the poor and the homeless. I don't disagree with that. I like him. That's why I'm praying for him. He doesn't waste church money and things in public. Yeah. And that is, do you know what? I'm not Catholic, but that doesn't mean I can't respect and honor what he has done. And that doesn't mean that I can't show compassion and empathy for what he's going through. And that is exactly what I'm doing. So, yeah. Okay, let me do this. Let me stop sharing the screen, because I can't do this without doing it the way I'm doing it. I wish it was more seamless, but it's not. It's not. Didn't want to G5 it. Okay, let's see. I'm trying to embiggen it as best as I can, both for you and me. All right, new document. Commonwealth of Massachusetts. I cannot read this up here. Let me see. Can't see. That's all that happens. I can't fix that. Sorry, guys. But here it is again. Yay. I seem to recall that, Haley. I seem to recall hearing that. There's a lot of these documents are converted, so there is this is going to be inadmissible. Yep. Defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial prior bad character or propensity evidence. God, is that not a mouthful, y'all? Don't get quiet on me now. Let's keep the chat rolling. Okay. Now comes the defendant, Karen Reed. Miss Reed respectfully moves This honorable court in limine to exclude any reference to irrelevant, inadmissible, and prejudicial events that purportedly transpired on December 1st, 2021. Does anybody remember what happened on December 1st of 2021? I think I do. Was that not the event that they went to where she got jealous of him giving a hug to somebody that he knows, more of like a godchild type thing, a family friend, and she thought he was cheating on her and she got mad and there was a fight? Do y'all remember all that? Can y'all remember all that? Why is this giving me hell all of a sudden? It should move. Do what I'm telling you. Wait a minute. Why am I having so much trouble with it? I am so frustrated with everything I touch being so difficult. Yes, you are seeing my frustrations, y'all. Oh. Oh. Ugh. Escape it. Oh. I'll fix it later. I have something blinking and it's distracting me. So anyway, I think that was the situation where he and Karen Reed had a horrible fight. And that came in as evidence. Uh-oh. Uh-oh, y'all. I'm missing a monitor. Oh, Lord. Y'all just went down. Hold on. Sensei, out. No, Sensei, out. I have a little doggy who has a little tail who climbed through all the wires and knocked out my cord. There we go. Back on. I need that monitor because I got the case on that. Okay. So I think that December 21st of 2021, where was that trip? It was some big trip. As grounds for motion, the defense states that the proffered evidence is not relevant to any material issued in this case. See Mass R Evidence 402. Should the court find that the child's evidence is relevant, it's the children, and any potential probative value of the proffered evidence is outweighed by the substantial risk of unfair prejudice to Miss Reed. I like this app. Miss Reed is accused of the following crime arising out of the death of Officer John O'Keefe. Murder second degree. We don't need to read all that. The defense suspects the Commonwealth will again seek to admit testimony regarding the completely irrelevant verbal argument between Miss Reed and a woman named Marietta, Sullivan, which, that's it. The Aruba trip. I was right. Occurred on December, the Aruba trip, December, is it 31st? I think it was this 31st. It was New Year's Eve. For the sole purpose of trying to associate Miss Reed's character in the to assassinate Miss Reed's character in the eyes of the jury. At Miss Reed's first trial, every single witness unequivocally testified that there was no history of violence whatsoever in Miss Reed or Mr. O'Keefe's relationship, and that two of them were in good spirits the night of January 28th, despite the Commonwealth's repeated, illicit, inadmissible testimony regarding the verbal incident that occurred in Aruba 1 month prior between Miss Reed and a third party, which had no logical relationship to the crimes charged. And do you know what, guys? I don't disagree with that. Just because a couple has an argument does not mean that she is capable of unaliving or he is capable of unaliving. The Commonwealth has no reliable evidence suggesting that the Aruba incident had anything whatsoever to do with John O'Keefe's death a full month after January 29, 22, or that this remote, isolated incident was even a point of contention with Miss Reed and John O'Keefe. A relationship after, I don't know, at the first trial. Oh, after the trial. At the first trial, Laura and what was her name? Marionette Sullivan testified about a highly inflammatory incident in which Miss Reed apparently got angry at another woman, not the decedent, because she purportedly believed John O'Keefe had kissed a woman. The Commonwealth initially admits this poor bad act and character evidence for no other reason than to sully Miss Reed's character in hopes that the jury would indict her on basis of the fact that she was, in Marionette Sullivan's words, an asshole. Asshole. In trial, Laura Sullivan admitted that she was not present during the verbal exchange between Marionette Sullivan and Miss Reed. So her testimony on December 31st incident in Aruba is almost entirely comprised of inadmissible hearsay. Getting jealous is not a crime, does not make for a murderer. You are right. Despite the court's limiting instructions about bad character and propensity evidence, the Commonwealth was permitted to elicit I can't say this word, prejudicial testimony from Laura Sullivan, and Mr. O'Keefe purportedly called Miss Reed crazy and that he had insulted, excuse me, this is getting a little, I need to start outlining, and that he had insinuated he was unhappy in their relationship. Marionette Sullivan trial testimony was also extremely prejudicial and to Miss Reed. Her retelling of a verbal dispute with Miss Reed was not probative in any material fact or element in the case, and it culminated with Marionette's telling the jury distinctly that Miss Reed sucks. As is set forth within, the evidence must be excluded. Argument. The Aruba incident, other unusable prior to bad acts and character evidence, any relevance outweighed by the risk of prejudice to the defendant. Motion in limine concerning the introduction or exclusion of properly relevant evidence properly and made. I need to sing it to make it right. Considering, therefore, at trial, in advance of the evidence being offered, Commonwealth, blah, 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 blah. The proposed motion in limine is to prevent irrelevant, inadmissible, or prejudicial matters from being admitted into evidence, and in granting such, I don't know, the judge has discretion similar to that which he has when deciding whether to admit the evidence. And that very well may be. And yes, you may say your piece, and you will be respected. People may want to argue that with you a little bit, but as long as you guys can debate kindly and nicely, that's fine. But you here have a right to your opinion. Thank you for being respectful. You will be respected back, even if we do agree to disagree. But do you know what? One thing I'm going to do when we get into this trial is I'm going to wipe everything else out, and I'm going to focus only what's presented in trial. Believe it or not, I can do that. And see if I come to the same conclusion. It is a fundamental rule that the prosecution may not introduce evidence that the defendant previously has misbehaved. Okay, in whatever or not, for the purpose of showing his bad character or propensity to commit a crime charge. Although this type of evidence is sometimes admissible for other relevant purposes, such to prove a common scene pattern operation, absence of an accident or mistake identity, ... This is all in that motion. Similarly, although the evidence of the hostile relationship between the defendant and his spouse may be admitted as relevant to the defendant's motion to kill the victim, such evidence should not be admitted if it relates to events which occurred at the time too remote from the killing. So they're saying this is too remote and has nothing to do with the Karen Reed case. So herein is no such logical relationship. In order for the evidence of prior hostile relation something to the defendant's motive to kill the victim, the evidence must actually something between the victim and the defendant to see. It's all garbled, y'all. Sorry about that, but we'll get there. You know what? I've had a lot of people talk about the smirking of the court. And there's some people have behaviors they do when they're nervous, anxious. Sometimes it's a smirk, sometimes it's a tick. God only knows.
The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven.
I've been following the O.J. Simpson thing with Court TV because I sent them a clip, and I could probably won't be, but could be in it. Some people laugh when they're nervous. Some people fidget. So I don't know her well enough, and I don't have enough video evidence of her behavior outside of this courtroom for me to draw a conclusion. But I can see how it can be taken that way. A lot of case citing. We're going to skip that. Okay. A lot of case law. This case law is not comparable to this incident during which Miss Reed briefly became angry with another woman, not the decedent, because she believed that O'Keefe had kissed that woman. There was zero physical violence here, no threat of violence, no police involvement necessary, and absolutely no history of violence in Miss Reed and Mr. O'Keefe's relationship. And that is something that I wish they would have brought out a little bit more in court, because that is so true. Moreover, even when this type of evidence might be relevant for some limited purpose, the evidence must be excluded if it is probative value is outweighed by the risk of unfair prejudice to the defendant. I am really tired. Then it's admissible. I'm not going to read all the codes. Massachusetts courts have long held that where evidence is prior of bad acts is relevant for the purpose such as intent or motive, it should be excluded if the probative value is outweighed by the risk of unfair prejudice to the defendant, even if the substantially outweighed by the risk. Yeah, I agree I agree it should be kept out. Here, the testimony by Marianetta Sullivan and Miss Reed became angry with Marianetta. No something deceit on December 31st of 2021 because she believed that Marianetta had kissed her boyfriend, John O'Keefe, is simply not probative as to whether Miss Reed had an intent to redrum John O'Keefe on January 29 of 22. This event was remote in time and was clearly and not an issue between O'Keefe and Miss Reed on the night in question, as evident by the video surveillance footage at the Waterford Bar and Grill And on the night in question and the testimony of 8 witnesses, all of whom agree the couple appeared happy and to be in good spirits. There's no legal relationship between the Aruba incident and the client charge. Why is my thing? Great. I've lost the monitor. I'll have to fix it when we get back into testimony. There's no logical relationship, and Commonwealth attempt to characterize the misunderstanding as some sort of turning point in Miss Reed and John O'Keefe's relationship is off base, unsupported by the evidence. The sole purpose of the Commonwealth attempt to admit the evidence is solely something Miss Reed's character, I'd say, to soil Miss Reed's character by allowing Marionetta Sullivan, that's definitely a typo, to testify at Miss Reed, quote, sucks. If you are to believe the Commonwealth's best evidence, i.e. that Miss Reed said, go furk yourself to Marionetta when she was temporarily believed that she observed Marionetta kissing her boyfriend on New Year's Eve in Aruba, that evidence is simply not probative of a motive to murder Miss O'Keefe more than a month later, when the parties were, by all accounts, in good spirits. In the order for there to be a logical relationship between the prior bad act evidence and the crime charged as required by the Commonwealth versus Pino 485 Mass 386-2020, the jury would need to believe that Miss Reed reacted with a verbal go furk yourself when she believed that she was observed an adulterous behavior on January 31, 21. But then subsequently flew into a murderous rage a month later when this event was remote in time and not the subject of any argument on the night in question. The type of reasoning defies logic, and Miss Reed's short-lived anger was not even directed at Mr. O'Keefe, and her apologetic conduct after the incident demonstrates she knew the kiss could have been misunderstood. The only reason for the admission of this evidence is to sully Miss Reed's character and prejudice the jury against her. Don't worry about your Spanish way of being. I like your Spanish way of being. You can be your Spanish way of being all you want here. We welcome it. Gerald says, inadmissible because there's no relationship. I agree. Simply looked at the evidence and don't see the injuries matching hit by a massive SUV. Yeah, I still struggle with no bruises, and I'll talk more about that later. But I can play the devil's advocate really well. Miss Reed reasserts here that the evidence has a 710 probative value regarding the crimes for which she has been indicted. However, even if the court finds that the evidence is relevant in any marginal relevance of Miss Reed's temporary belief that O'Keefe kissed another woman 1 month prior might have terms of evidence of a hostile relationship or intend to murder far outweigh the prejudicial inflammatory blank. I don't know what that is. It's just garbled. It would have on the jury, I'm going to say inflammatory influence on the jury. We are almost done. The Commonwealth must be prohibited calling witnesses to testify to the inadmissible for the purpose of amending to show relationship. Moreover, the Manassas Court, I used to live there. Massachusetts State Court have long held that the admission of hearsay statements for the purpose of showing a hostile relationship between defendants and the victim is not permissible because it would entirely obfuscate the rule important proposing of ensuring the correctiveness and completeness of testifying through cross-examination. Commonwealth argues a prior proceeding that this testimony is admissible in order to show the defendant's state of mind, excuse me, is misguiding. Again, the evidence in Aruba took place a month before John O'Keefe's death. There's no evidence suggesting that Ms. Reed was still upset about it on January 28th of 2022. Okay, if you don't mind direct Spanish way of expressing myself, I would like to say I don't like the way she behaves in court. Furthermore, I dislike her. And do you know what? You can hate her. I can dislike her. There's people that we've watched here that I absolutely detest and wouldn't have a cup of coffee with. But I couldn't find them guilty because the evidence was not proven beyond a reasonable doubt. And that's so hard because if it's not proven beyond a reasonable doubt, then you cannot convict. I don't care if they like you or not. I don't care if you like me or not. You could hate my guts, but if you do your job correctly, you look at the evidence, and if there's not, I mean, if there is any reasonable doubt, then you can't convict. You can't convict on whether you like someone or not. You can't convict whether you like their hair, their body movements, their mannerisms, the way they talk, unless you're Sarah Boone. And then that's an exception to the cause. I know, isn't that horrible? But no, I have no problem with everybody being honest just as long as you're respectful. And both sides of that coin can be true. Her testimony by Laura Sullivan regarding the irrelevant and inherently prejudicial Aruba incident must be excluded because the witness has nothing to testify about other than the admissible hearsay of the prejudicial character evidence. Indeed, during the 2024 trial proceedings, the Commonwealth chose to put Laura Sullivan on the stand to testify about an incident that she didn't even witness in Aruba of December 31 or 21. That involved Ms. Reed and Mr. O'Keefe and the sister, Marionetta Sullivan. Laura Sullivan was also permitted to testify about her completely irrelevant negative impression, and that was right, of Karen Reed during the planning of the Aruba trip. See, even if she didn't know her, she didn't like her from what limited knowledge she had of her, and everything that about the incident with her sister and Karen was hearsay. She didn't witness it. She was told about it. Again, hearsay. Okay, that Karen Reed told her she needs her own bathroom and that she didn't want to share a room with John's kids. Now, by the way, for those of you who don't know, she has really severe Crohn's disease, and on top of that, at one point had a life-saving surgery, which left her with a colonoscopy. I can't say that. Colostomy bag, and it has been since reversed. But if you have that kind of a problem, I wouldn't want to stay with children and people in a bunch of room when I knew that I spend a lot of time in the bathroom with a lot of bowel problem. I can see why she'd want her own bathroom and wouldn't want to be with a bunch of people. She's had cancer and multiple sclerosis. So this woman had a lot of health issues. And boo, at my age, listen, I don't even want to stay with my own kids. Give me my own room in bed, please. If she's willing to pay for it, let her have it. But that doesn't mean it's like me saying I would like a handicap room. And you don't think I need one. It's none of your business. You don't know my history. You don't know my medical conditions, and you don't know my life. That's how I saw that. Karen Reed told her own bathroom, and she didn't want to share with the Commonwealth. Then elicit additional inadmissible prejudicial hearsay testimony from Laura, who told the jury that John O'Keefe told her, or somebody O'Keefe, I guess it may be John, that Karen is crazy during a later conversation that night, December 2021, and that on January 2nd, 22, John insinuated that he was unhappy with the relationship, all of which is hearsay. All of which is hearsay. Noticeably, Gerald. Notably, the Massachusetts state courts have long held that the admission of hearsay statements for the purpose of showing a hostile relationship between the defendant and the victim is not permissible because it was entirely purpose skewing. I don't know. The correctness and completeness of testimony through cross-examination, ... When I say ... that's case law. Thus, all all of Lauren Sullivan's testimony regarding the Aruba trip continues to be prejudicial and inadmissible hearsay, which must be excluded. In conclusion, ... You've got Jackson Prohakvis. You've got Elizabeth L. Little Esquire Prohakvis and Yannetti all signing that little baby. And there you go. All right, the next one up on the docket. I don't know how many pages this is. Not too long. Well, I don't mind sharing a hotel room with kids or anything. I was in the Sweet Adelines. I used to sing with 120 women, and we traveled as a chorus. It was barbershop a cappella stuff. And we would travel to competitions and stuff as a chorus. I have slept with more women than many men could ever dream of. That meaning I shared a room with 4 women, sometimes 4, most often, including me, 4, sometimes 5, and 1 bathroom. I get it. And I was the youngest by far all the time. I was super young then, a very young person, and they were older. They were my age. And I ended up on the floor, sitting on the floor, looking into the wall mirror while a woman stood over me. We both sharing one mirror. I was low. She was, yeah. I can appreciate John brother has smiled and laughed in the courtroom. It's his own brother that has lost his life. It's hard for us to know what they're reacting to through the screen. And that's true too. That is true too. But everybody has a right to their opinion, and I appreciate your opinion, and I do appreciate your views, because if we don't have someone challenging us, how do we know that we're right? Give me a challenge. I'm okay. Say, hey, have you thought about this? I disagree. Just we can agree to disagree and keep going and smile. Okay, let me throw this document up there. And I appreciate all of you guys. I really, really do. You're simply the best. Okay. Let me see if I can make this a little bigger. I wish I had a Mac with the big screen, the big Mac, flat, all computer in one. I love my PC, but I would love a Mac for the documents, because the documents are better and easily manipulated on a Mac. Defendants motion to impound portions of the defendant's motion in limine to exclude certain witness before and after testimony. Huh? All right, let's see. Now comes defendant Karen Reed. Ms. Reed respectfully moves the honorable court in order to impound proportions of the defendant's motion in limine to exclude the Commonwealth of Massachusetts Norfolk Superior Court Department, blah, 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 motion in limine to certain witnesses before and after testimony. Okay, here we go. Let me get it up. I thought it was up. I said, put it up. Put it up. Come on. There you go. Now comes the defendant, Karen Reed. Ms. Reed respectfully moves the honorable court for an order to impound portions of the defendant's motion in limine to exclude certain witnesses before and after testimony motions, namely portions of the motion reference text messages that link, subject to a protective order issue in connection with this case, Exhibit A, containing a copy of those undersigned and whatever. It's not going to get it. Exists for the impoundment of this information because it is subject to protective order. I need to quit leaning in like that. Ugh. In support of this request, Ms. Reed hereby submits 2 copies of the defendant's motion and 1 undersigned copy. Defendant's motion for the court file, 2 copies of motions with all references and copies of the text messages that are subject to protective order redacted such that they are not visible to the public. There, that was the redaction. I, Attorney Elizabeth, hereby certify that I served on the motion to impound portions of the defendant on the motion and eliminate, exclude certain witnesses before and after testimony. So she's saying she put this together. Okay, this is 560. You guys, I have so many of these. Okay, I'm going to open up 561. Give me a momento. There it is. Let me get it and big and just a little bit more. I like it a little more big and for y'all. And see, it disappeared again. I think this is actually a StreamYard issue and not my computer issue because I don't have any problems in any other programs. I think there may be an update I need to do. We'll check that when we get off this evening. Oh. Okay. Get that back up. Affidavit of Elizabeth Little in support in the defendant's motion to impound. Wait a minute. I want to get to that motion to impound. So let me go to another document. Let's find that first. I'm going to put that. It's trying to open. Ooh, it's getting hot in here. Can't do it with the light box is open. Please look that. Okay. This is something different. Okay, we're going to read this one. Don't worry about it. We'll get back to that one. But some of these are out, even though the numerical order is that. The numerical order is there. I want to read the other document before it opens up. So please, we'll see everything. I'm trying to get it somewhat in order. I'll put that on the taskbar so I know it's there. Okay, we're gonna see. This won't let me switch screens, so I stop and share again. Okay. The defendant's motion in limine to exclude certain witnesses before and after testimony. This is a different one, I think. Respectfully, honorable court, let me exclude certain witnesses after and from courtroom. Okay, this is them requesting that the witnesses not be permitted to be in the courtroom before and after the testimony. On the defense side, this is their request. Now comes defendant Karen Reed. Ms. Reed respectfully moves this honorable court in limine to exclude certain witnesses from the courtroom before and after testimony and trial of matter rule of sequestration of witnesses of the Massachusetts Rules of Criminal Procedure state that upon his own motion or the motions of either party, the judge may, prior to or during examination of witnesses, witness or witnesses or witnesses. Yeah, you're covering all bases on that. WITNESS, WITNESSS, or WITNESSES, other than the defendant to be excluded from the courtroom. The power of a judge to control the process and within the limits of the adversary system in the shape of this trial is universally held to include the broad Can you pick it up? Power to sequester witness before, during, and after their testimony. Citing a whole bunch of stuff. Let's get past the cites. Ms. Reed specifically requests the court to exclude its broad discretion to exclude the following. Now, here we go. Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, Brian Higgins from the courtroom before, during, and after, or before and after their testimony at trial. Thank you so much, Lady Jane. And I know Haley Mouse will be leaving us shortly. Gerald, thank you so much for hopping in again. And frankly, all I'm interested in is to get the truth. A man lost his life. I just want justice for him and his family. End of it. And do you know what, Elena? You want the same thing we all want. We all want the same thing. We may not agree on who and how it is, but we all want the same thing. Okay? So, Honey Boo, you're in the right place. Okay. As the court likely recalls, after they testified, members of the Albert and McCabe families proceeded to sit in the gallery with the O'Keefe family facing the jury, supporting something. What is that? Subordinately, whatever, through the remainder of the trial, including closing arguments. Following the trial, a juror reported to Vanity Fair magazine that he or she felt was utterly inappropriate that the Albert and McCabe families were able to stare down the jury from their positions in the courtroom gallery. Miss Julie Miller, Karen Reed tells her story per Z, Vanity Fair, 2024. One juror reported to Vanity Fair magazine that he or she felt intimidated by the presence of the Alberts and the McCabe families, calling their presence in the courtroom something gallery, facing the jury completely and utterly inappropriate. Julie Miller, Karen Reed tells her story part 2 again, noting that the Albert and the McCabe families were substantial focal point of the trial. The juror noted how unbelievable it was that two families were allowed in something, I guess, to stare the jury down. This was exculpatory, prejudicial, and Miss Reed alleges third party culprits Brian Albert, Colin Albert, and Jennifer McCabe all sat in the gallery during closing arguments directly facing the jury, which according to at least one juror was intimidating. As the jurors heard through testimony, the Alberts and McCabe family's deep connections with the family ties to multiple state police forces and local governments, and acknowledged Mr. O'Keefe, a Boston police officer, Boston Police Department officer, was a part of this tight-knit law enforcement community. And by sitting with the families of the O'Keefe and continuing to face the jury for parts of the remainder of the trial, at least one juror felt intimidated by what he or she perceived as the Albert staring down the jurors. 100%, Elena. I am so disappointed in the investigation and the evidence gathering that leaves anything to be questioned. You would think that this being one of the Boston finest, which was best friends with the Canton PD, and a lot of them intermingled in businesses together outside of being police officers, you would think they would have done the very best they possibly could have done in this investigation. They would put, as they say, excuse the expression, balls to the walls and gone all out. There was no financial limit. They could have spent whatever they needed to, and they did not. John's dad wouldn't go to court on days where he was sitting there. He didn't think Karen did it. Well, and he, not only that, he didn't want to sit facing the jury. That was something else that was said. The courts have recognized that when a witness or a person stares down the jury, it can make the jurors feel timid or fearful. See Commonwealth, ... I'm not going to read all of that. Oh, thank you. Thank you so much. Here, the judge has broad discretion to order sequestration of the witnesses before or after. I'd say before and after. Gerald, thank you so much. Their testimony at trial. A defendant has a constitutional right to a fair trial to be decided by an impartial jury free from intimidation and undue influence. Given that at least one juror reported feeling intimidated by the presence of certain witnesses towards the end of the trial, Ms. Reed respectfully requests the courts to exercise a broad discretion to issue a sequestration order excluding the Alberts, Nicole, Brian, Colin, Julie, Chris, and Jennifer McCabe. There's 2 B's in that, babe. Matthew McCabe, Brian Higgins from the courtroom before and after witness testifying or testimony to prevent further prejudice. For the above reasons, signed. All the attorneys signed. And it is signed, sealed, delivered. I'm yours. Okay, 64. Trying to go in order, y'all. Okay, here we go. We got another one. I just wanted to make sure I didn't put up the same one. I got so many of these, y'all. It isn't even funny. Enable. Give it a second. It's going to do the enable so I can biggin it. You've got me for a bit longer today, Ada, because the clocks haven't changed yet. Oh, lucky you. Ours have already changed. I wish they would just leave it where we are now. Please, can we leave it where we are now? Please. Now comes the defendant, Karen Reed, respectfully moves this honorable court, and I struggle saying, I'm getting it, this honorable court, because I don't find this woman honorable in the least at all. She's not honorable to me. Let's see if I can embiggen this just a little more. Some of these move a little bit, change a little bit. One more. Let's see if I can get that. I'm doing some resizing. Hold on, guys. Let's see if I can move that there and move that there. Is that better? I hope so. I'm going to save it and see what y'all think. Okay, let me get this over here. Okay. The defendant's motion eliminated view. Now comes the defendant, Karen Reed. Ms. Reed respectfully moves this honorable court in pursuant of MGL 234A or 69A to order that the jury be taken on a view of the alleged crime scene. Oh, they want a looky-loo. Ms. Reed respectfully requests the court order that the something road Fairview order a. This is so messed up. I'm going to say a looky-loo on Fairview Road in Canton, Massachusetts, into the exterior of the 21 something, I guess, here after the vehicle. Oh, they want them to show the vehicle. Ms. Reed further requests that the vehicle be towed to a public roadway in front of 34 Fairview Road, Canton, Mass. And Ms. Reed requests this honorable court permission. Ms. Reed to attend the view, subject to any reasonable restrictions of the court deemed necessary. They're wanting a massive looky-loo. I would love for them to put a dummy there and have somebody in the snow, in the same conditions, try to back up that fast, that short in snow and hit him and see where the dummy lands. Just saying. GL 234A69A provides that the court may order a view by the jury impaneled to try a criminal case. Ms. Reed states that permitting the jury to view the crime scene located at 34 Fairview Road. By the way, case in point, if you go and Google 34 Fairview Road, it is blurred out, and the chief of the Boston PD's house across the street is also blurred in Google. So the court ordered that those 2 homes be blurred off of Google because of this. And that the vehicle at issue, the alleged murder weapon, would assist the jurors in reaching a verdict, allowing the impaneled jury to view the crime scene located at 34 Fairview
road would particularly be useful because the lawn appears to be more expansive in the photos than it does in person. This is true. In addition, allowing the jurors a visual inspect the vehicle will assist the jurors in assisting whether Mr. O'Keefe's injuries are consistent with having been struck by any portion of the vehicle. The chief purpose of the view is to enable the jury to understand better the testimony which has or may be introduced, quoting the Commonwealth versus the name. I can never say those. Daskalaski. Daskalaski. I did it. Daskalaski. Although what is seen on the view may he use what? Although what is seen on the view may be used by the summary in reaching. Oh, thank you. Although what is seen in the view may be used by the jury in reaching their verdict in a strict and narrow sense of the view may be thought not to be evidence. Proper speaking, no evidence should be taken, no testimonial comments made during the taking of the view. It's a looky-loo. Massachusetts ... As with the decision whether to hold a view, the decision to allow a defendant to be present is within trial judge's discretion. Dansky was obligated to the grounds of Commonwealth, blank. For the above reasons, we respectfully request the Honorable Court to allow a motion for a view. Okay, moving right along. That was that 65. I may have to open up the next one. Y'all, we're moving through. We're not halfway, but we're moving. Oh, my brain is starting to hurt. Next. Let me get it there. Let the enabling. It's taking a minute to open. Open sesame. Boom. No. Present. Share screen. Window. Click. Share. Thank you. No, got to embiggen it. Hide. There we go. Defendant's motion to something testimony regarding funds paid to expert proposed of voir dire. Now comes the defendant, Karen Reed Misby, respectfully moves this honorable court in limine to exclude testimony regarding expenses, not. Do y'all see this? That is definitely a conversion problem. Oh my God. I almost read that out loud and that would have cut me off, y'all. I would have gotten in trouble for reading that. Expenses incurred by Miss Reed for export voir dire. Given that these expert expenses were irrelevant based solely on the request of the Commonwealth to mandate the court that their inclusion in the testimony would not be probative of any facts of consequences that would only be something produce whatever towards the prejudicial. Thank you. Towards the defendants. There's something with the problem. Preju. Dishal is fine. Prejudicial. It's that dyslexia kicking in. Factual background. And by the way, if you those who don't know me, yes, I am literally dyslexic. I'm not making it up. It's one of my quirks. Sometimes it can be fun. In advance of both the first and the second trial in this matter, Commonwealth. Come on, I guess again. And the court ordered in the person voir dire for expenses expert witnesses, including Dr. Daniel Wolf, Dr. Andrew Rentschler, and Dr. Marie Russell. As a result, Ms. Reed has to expend significant resources to pay for out-of-state experts to travel to Norfolk. If it's said right, it sounds like something else. Norfolk County, Superior County for voir dire hearings, which spanned multiple days. Oh my God, 3 days for Miss Russell was insane. To the extent that the Commonwealth seeks to cross-examine those experts regarding any fees they have been paid to testify in connection with this case, the Commonwealth should be precluded from eliciting testimony regarding any fees expected to have the experts testify at voir dire hearings, which were conducted at the Commonwealth's request. That's right. They're not saying you can't say, "Are we paying you for your testimony today?" They don't want to bring up, "How much money have you been paid overall?" That would include the voir dire amounts, and that's not fair to the defense when the defense did not want that to happen. The Commonwealth demanded it, and the defense had to eat it. So, I agree with them. Okay, expenses incurred by Miss Reed as a result of the export voir dires are irrelevant. The fees and the expenses related to export voir dires are entirely irrelevant to the expert credibility and do not make any fact of consequence more or less probable. Discussion of the facts that our expert witness is compensated for their time is acceptable so that juries may assess expert credibility and bias. Holding that while the discussion expert trends and fees is acceptable suggestions that the expert is a hired gun is impermissible. However, testimony, oh yes, thank you, about the facts and expenses occurring as a result of voir dire have no bearing on the expert's credibility at trial. This is particularly the case here where in-person voir dire conducted at the request of the Commonwealth. Portion of that voir dire expenses came from traveling and lodging. Discussion of fees and expenses incurred by the defense for the expert voir dire would not provide the jury any additional clarity about the expert motives or bias. The in-person voir dire of experts was conducted at the Commonwealth's request. Moreover, the defense would have a way of clarifying the issue on redirect without eliciting the fact that there was a voir dire hearing, which is information the jury should not be privy to and would not understand. Voir dire fees and expenses are separate from potentially relevant fees and expenses incurred at trial and therefore should be excluded. I'm not going to read all of this because it's rhetoric. It's overly. Ultimately, disclosure of the fees and expenses incurred for an expert voir dire would create an inaccurate, improper image of Miss Reed's financial situation, causing an unfair prejudice and I did it right. And it's the I can't say it now. And the serious risk of thus making credibility of the fact that voir dire was conducted at all. Both results would be unfairly, there we go, prejudicial, and outweigh any potential probative value, more case, conclusion. We're done with that. I know it is so difficult sometimes to read this. Oh. Oh, someone just sent me some pictures. Okay, let me get this up. No, I don't want to leave the studio. Quit asking me. Okay, so here is a defendant's motion for ordering, prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they've taken the stand. Okay, so if you remember, those who watched the last trial, Jennifer McCabe got up on the stand and perjured herself. And then they took a break. During that break, the prosecution met with her and obviously had a discussion about it, because when she got back up on the stand and they continued to ask her questions, she did go back and correct and elicit testimony that she shouldn't have. So they're saying once a witness hits the stand, you can't talk to them at all. You can't have lunch with them. You can't do anything during break with them. You can't talk with them at all. And no wonder it's 4:00 almost. I want my tea. Been looking for my tea. Nice picture. So here comes the defendant, Karen Reed. Miss Reed respectfully moves this honorable court to issue an order prohibiting the Commonwealth and its agents, including, but not limited to, oh, shoot. I can't. Why is it wanting to do that? That's not what I want it to do. I want to highlight. I can't highlight, can I? No. Why can't I? Okay. Okay. Commonwealth agents, including but not limited to the prosecution, law enforcement, victims, witness advocates. So all of these people are part of the Commonwealth. None of them, they do not want them being able to talk to a witness once it takes a stand. So the victims, witness advocates from speaking with or having any contact with any witness once a witness has taken stand. During Miss Reed's first trial, defense learned that the Commonwealth was having an improper conversation with witness while they were in the middle of their testimony. For example, there were many of them. One, for example, on cross-examination, Brian Albert indicated that he had spoken with the assistant DA, or Ada, me, Adam Lally, over lunch hour while the court was in recess. During the middle, trying to pop my neck, of his testimony, when asked what had they discussed, he initially denied speaking about the substance of his testimony, but then later admitted that ADA Lally had discussed some topics he wanted to talk to him on redirect. Quote, he may have mentioned one thing he may ask me. Just he was going to ask me about what happened in the house in the morning. You know, some of the questions on redirect, that's all. As for grounds this motion, Ms. Reed states that the court has the discretion to prohibit communication between witnesses, attorneys, and third parties. Argument. In order to preserve the true seek and functional of the trial, the court should prohibit agents of the Commonwealth from communicating with witnesses once they have taken the stand. This is of particular concern during the recess or lunch breaks, in which there is virtual certainty that any conversation between the witness and the lawyer could relate to an ongoing testimony. Blah, blah, blah on the rules serves as an important function in preventing one witness testimony from being inadvertently molded by the testimony of another witness. Rule something, something 21 report note that the same danger with witness testimonies may be molded in conversations other is present when the witness speaks with something prosecution or other agents of the Commonwealth during breaks in testimony. Conclusion. For the above reasons, Ms. Reed respectfully requests this honorable court issue kind order prohibiting the Commonwealth and its agents, including but not limited to the prosecution, law enforcement, victims, witness advocates, from speaking with or having any contact with any witness once they have taken the stand. All righty then. That will go to say, I think that's good. I was wondering about that because they had that problem. They had that problem big time with Albert and Jennifer. I mean, it was not good. I was shocked that they were able to have those kind of discussions. They shouldn't even be looking at each other. They shouldn't be eating in the same place. They shouldn't be, I mean, even in the bathroom. If a witness goes in the bathroom and you're an attorney, you walk out. Wash quick and leave. Okay. Next. The defendant's motion to impound defendant's motion to eliminate, to exclude irrelevant and prejudicial evidence regarding an alleged harassment, intimidation of witness. Oh, Lord, here we go. Now comes the defendant, Karen Reed. Miss Reed respectfully moves this honorable, I want to do that from now on, honorable court for order impounding defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial evidence regarding, oh, yes, please sign. In other words, the intimidation of witnesses. Good cause exists for impoundment of this something because it makes reference to the grand jury proceedings. That is true. That they cannot do. You cannot do that, y'all. You can't. Sorry, dude. Are y'all there? Did I lose you? We are now about halfway through. Some of the longer ones I think are getting ready to come up. Let me get this up and going. Hide window. Affidavit, Elizabeth Little, support of the defendant's motion to impound. We're not going to look at that yet. I got to find that motion to impound. That was that one. Nope. There is 4 of these motions for the impounding. So we're not going to read those. Basically, they did by disposing the state of the following that they put it in, that she did it. Okay, enable editing this one. We'll get it up there, y'all. Give me a minute. John. Let me get rid of this other one. Okay. Defendant's motion in limine to exclude serum plasma concentration, blood, ethanol concentration, and conservation corresponding to whatever. Oh, she wants her blood test removed. Now here comes the defendant, Karen Reed. Miss Reed respectfully moves the court in limine to there was no honor. There was no honor. Yay. Exclude the evidence of something plasma ethanol concentration test performed by Good Samaritan Hospital at 9:03 a.m. January 29 to 22. By exclusion, Miss Reed necessarily moved to exclude the blood ethanol concentration conversion performed by Massachusetts State MSP, as well as the corresponding exploitation analysis. Reed states that as the grounds for this motion, Miss Reed acknowledges by something forensic scientist Nicholas Roberts, the ethanol results used for the reports was provided by an external party. The testing to obtain the ethanol performed at the MSPD crime lab, and therefore reports don't fail under laboratory scope of accreditation. So what they're basically saying, it was not taken by the Massachusetts State Police Crime Lab or CSI, MSPD CSI. and under their control, that they are saying that those reports should be removed. Since the Commonwealth cannot establish that the blood test resulted administered by Good Samaritan Medical Center is reliable for the purpose of criminal prosecution, the serum blank ethanol concentration results and corresponding blood ethanol conversions and retrograde extrapolation of which derives their results from the initial results should be excluded and unreliable. Oh, thank you. Oh, that's better. And not to be produced of reliable principles of method. So the thing is that the problem is I had a problem with those numbers because she's got several medical conditions that would change the ability and the speed at which she processes alcohol. And none of that was taken in consideration. In fact, none of her medical conditions were brought up except for when the lovely Albert called her. Was it Chris Albert called her leaky blow knot? So distasteful. On January 29th, around 7:26 a.m., Miss Reed was admitted to Good Samaritan Medical Center as a result of acute grief reaction she experienced after learning that her then boyfriend, John O'Keefe, had passed away. She lost her cool. In addition to evaluating her, but even the EMS and paramedics were disagreeing with the police on trying to get her Section 12, which they did, meaning they put her in for a psych eval. She was apparently making accusations she wanted to unalive herself. In addition to the evaluating her, the hospital performed blood work and urine drug tests, which included tests for presence of drugs and alcohol. Ms. Reed tested negative for any drugs for which the hospital screened, and the hospital, however, recorded an alcohol level in Miss Reed's blood of 93 milligrams DL. Using the value from the test conducted by the hospital without ever having applied for a warrant to themselves test Miss Reed's blood, as would be normal course of a prosecution involving any aggravated form of, I guess, driving under the influence. Massachusetts State PD performed a controversial conversion of the report 93 ml-DL, don't know what that is, related to blood concentration ranging from 0.078 grams to 0.083 based on 3 different conversion actors. Okay, I had a problem with this. This is super high for that time of the day. That would mean that she would be drinking all night long, all morning long, and not gone to sleep. On May 4th of 2022, using the conversion Miss Roberts then conducted on July 6th of 22 in both reports. Miss Roberts explicitly notes that the serum plasma ethanol conversion obtained from Good Samaritan was not performed at the Massachusetts State PD crime, I guess, lab, and therefore, crime center, okay, and therefore reports does not fall under the laboratory scope of accreditation, and that's true. See exhibit blah blah administration manual update conversion factors of the Massachusetts State Police Crime Lab to align with the ANSIASB best police recommendations. Exclude that data. They should have gotten a warrant. Well, let me ask you, those numbers, what do you think about those numbers here, Gerald? 78.078 grams percent to 0.83 grams percent. Isn't that high? Or am I reading that wrong? I'm going to keep on because we're going to get back to court in a minute. Massachusetts Crime Lab now between 7.078 and 0.82. Yeah. And she supposedly took her last drink at midnight, and this is 7 a.m. She would had to be downing shots all night long to get that high. And then how was she able to drive? How was she able to be calm and cool and On the scene, there was not one police officer or paramedic or EMT or anyone that could say that she appeared to be drunk. She did not appear to be under any influence at the hospital. She was grief-stricken, at the scene. That's right. A warrant would only take a few minutes. Moreover, Knoll's report, she used a time interval of 8.5 hours with an additional 2-hour allowance from the time of 12:45. That's about the time she says that she got home. The time of the alleged incident they think the incident happened. So that's what it was. She thinks at the time that the alleged incident happened about 12:45 that she was at 0.078 and 0.082. Will she be able to drive a car? She's all of 100 and something pounds, 110 pounds, if that much, with Crohn's disease and all of this other stuff. There's no way she could drink that much alcohol and be vertical. And the chain of evidence was broken. Thank you. I really like your brain right now. The time at the incident account for the uncertainties associated with drinking history and the subjects before something interval. Her calculations determined Miss Reed's BAC could have been 0.14 to 0.28 grams percent at 12:45 in the morning. Yes, thank you, Gerald. By the way, you want to tell them why you know this information, or we'll just let them keep guessing? I don't know why all this stuff looks like this on the side. It's driving me bat crazy. Because both of the initial seroplasma conversion reports of the respondent, I can't read that. Give it a chance. Exploitation of the mathematical calculation, use CO estimate a person's blood alcohol level at a particular point in time by working backwards from the time the blood was taken into consideration. Commonwealth versus scene. Okay, I can't read all that. Exploitation. Breathalyzer test results are generally inadmissible without the need of Thank you. Breathalyzer test results are generally inadmissible without the need of retrograde extrapolation, without the need for expert testimony when taken within reasonable time. Defense by the SIC as 3 hours after the operation of the vehicle. Something lays out the narrow. We're not going to look at all that. Required where the Commonwealth is proceeding under an impaired ability theory as opposed to a something's theory and a test is administered the test is administered outside the 3-hour window, necessitating the retrograde extrapolation. Expert testimony is required. It's okay for you to say it, but look at this, guys. I trust that, and I agree with him. I would have said that too. I agree 100%. Just last year, the Supreme Judicial Court addressed an issue of a defendant consented to a blood test in a prosecution for a simple and aggravated form of OUI in comparison case, Commonwealth versus whatever. That any of the aggravated GIS or OUI ID accordingly, whether Miss Reed consented to the alcohol blood test or not, it is not an issue here. They getting, if there was any other judge other than Auntie Beth, there would be open can of whoop airs here. It would. I want to say whoop ass. Oh, I just did. Sorry. I'm long enough into this. We're only in 3 hours. Oh, that's right. We had the other live. What is an issue here is that the parties lack essential information about Good Samaritan Medical Center drew and tested Miss Reed's blood. First of all, correct me if I'm wrong, Gerald. When it's done within the confines of a warrant and at the Massachusetts State Trooper Pleady Office lab, the moment it comes out of that body and in a bag, there is a chain of evidence. Everybody who's touched it, what time it was touched, what time they drew it, what time they moved it, what time, whatever they did. None of that happens in a hospital. They'll initial it, date, time, initial who it was, give it a number, and they take it to the lab. It sits in a rack. People can go and handle it. It's not a chain of evidence. So why it was allowed in the first freaking trial, God only freaking knows. But we got Witchy Bev. I see here's a little witch with a puffet going. And what for reason? Because they said she was under the influence. Well, what about this? Why didn't you take the blood alcohol level of every Albert, every McCabe? Because they were all drinking. And why not go take the blood alcohol level of all the underage minors at a police officer's home drinking without an adult present, i.e. one of the parents? Nobody else was tested. And let me tell you, they drank a whole hell of a lot more than Miss Karen Reed. A whole hell of a lot more than Miss Karen Reed. Drop that. Why wasn't anybody else tested? So what you're telling people out there, it's okay to live in Canton. I'll tell you what, Gerald, I'm going to move to Canton. When I get my criminal justice degree in December, I can now be a police officer. I'm going to go at 54 years old and find a way to become a police officer so I can work in Canton PD and drink and drive and not get in trouble. I'll go party up the rest of my life, drinking and driving and not getting in trouble because I have a badge. They singled her out. You got it. What is the issue, however, is that the parties lack essential information about how Good Samaritan Center drew and tested Miss Reed's blood is a standard practice and procedures for OUI, and its aggravated form of one-on-one police to request to be granted a warrant. Ding, 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 ding. Thank you again, Mr. Gerald. So that they can test a defendant's blood through certified analysis in accordance. So why you don't have to go all the way back up here and have a witness try to figure out what they think the alcohol level would have been back then. I am too old to be a police officer. I could not pass the physical part. But let me ask you this. Why is it, and I've always wanted to know, why is it that in order to become a police officer, you have to pass the physical tests? Once you pass it, you can gain 200 pounds and have a beer belly hanging to your knees and can't run around the block and still hold a badge. Just saying. Just saying. Wouldn't that beat all if I became a cop in my county? Bar the doors, everybody. Okay, the medical records. Okay, let me get back up. I missed a little bit. They are police do not, and not to blank, blank, blank. They are not in a place to ensure that the blood testing for ethanol undergoes a standardized, reliable, repeatable. There it is. Repeatable procedure. Well, maybe I can never mind. I won't say that. The Massachusetts State Police utilizes gas chromatography testing rather than enzymatic immunoassay. Yeah. Which permissibly was used by the hospital here. So they don't even have an equal way. This is driving me crazy. Let me call my son. Hold on. My monitor is out. It's driving me crazy. The medical records provided under the chemistry section There is a regarding the drug testing which states this report is intended for the use of criminal monitoring. Hold on, let me re-say that again. In the medical records provided under the chemistry section, there is an issue regarding drug testing, which states that this report is intended for the use of clinical monitoring and patient management. It is not intended for the use of employment-related drug testing or court-related proceedings. Oh. There it is, folks. There it is. Samples are not routinely tested for adulteration and are assumed to be within the normal pathological pH range of 5 to 8. See attached. The alcohol result in beneath this annotation. It is clear whether this annotation applies only the urine drug screen or the alcohol result as well. Regardless, the defense should not have to guess. The Commonwealth should have at least provided documentation from the hospital regarding how the alcohol test results was obtained, through what procedure, by whom, and in what manner of testing was used, gas chemotherapy or enzyme testing. Oh, I lost it. The latter of which would yield a higher result. Are y'all seeing that when that pops up? No, you're not. What you don't see is I have a grammatic. I have that little ADI grammar thing, and I can put it over something that's like this that's spelled wrong, and it sometimes will pop up. Yay! That was so cool. Absent from this information, the Commonwealth is unable to establish the reliability. Something results on the facts. In light of the fact that the MSP, Ms. Roberts and Mr. Knowles, each separately acknowledged their respective reports that the whatever ethanol concentration test does not meet the accreditation standards for reliability, outlining the blah, blah, blah. We know with certain that the serum plasma ethanol concentration test wasn't very, I can't read it. There's nothing to read. Entirely different scientific protocol. The defense does not take issue with generally accepting scientific practice of retrograde extrapolation or whatever itself, but rather with the data upon which it was based, without reliable foundation information about the initial serum plasma result, the serum plasma conversion to blood proponent, concentration, and retrograde extrapolation of the converted numbers is not reliable. Oh gosh, I keep going. The Commonwealth has not provided any information about the initial result from the hospital that would indicate that the subsequent analysis by Ms. Reed or Mr. Knowles are accurate. Instead, 3 parties have involved in the BAC test have expressly disclaimed the legal veracity of these results. Certificate signed and sworn to by chemists of the Department of State Police or by a chemist of the laboratory certified by Title Department of Public Health, which contains the result of an analysis made by such chemists of the percentage of alcohol in such blood shall be prima facie evidence of the percentage of alcohol in such blood. Oh. At least not completely. The chemist who signed and sworn certificate is as admitted to the reports by the MSP. This testimony at trial, let's get to that. Thank you. This testimony at trial, thank you. You can't see it, but I can. Ms. Roberts admitted that while the standard lab testing procedure is to conduct 2 separate tests within the laboratory. Was Reed sample he conducted no testing himself and that merely assumed the hospital test was accurate. So not only is there a very questionable test, they should save that in a manner in which they can test it again. It should be audible. They should be able to do an audit on that blood draw. And let me tell you, with numbers that high, it should have been audited. I have a story about how I had lab work done, or I had a spinal tap done, and they told me everything was fine and sent me home. Long story short, that was on a Thursday. On a Monday, they did an audit of all of the tests the previous week, only to turn out that I was near death. And before they even called my husband to tell him that I was near death, they had already sent an ambulance to my home. Audits are good, and numbers like this should have triggered an audit. Both of their analyses were conducted with data that they did not themselves collect. Mr. Roberts himself confirmed an unreliable base for the calculations, like we have here, is a series for the reliability of the extrapolation results. Okay. You do, parentheses, you do have to base the extrapolation on calculation. A good blank, your starting blocks have to be good. So in other words, you got to start from good starting blocks or good ground, or it's not going to come out correct. So you have to know the time in which the blood was drawn, the time of the incident, and excessively what your value was for the BAC. All 3 of Miss Roberts' key factors are not clearly known. Moreover, the prior retrograde extrapolation, I may be saying that wrong, and I'm sorry, was not in keeping with the ANSI-ASB best practices, and thus new forensic scientist Hannah Knowles has now issued a report with a new and different range of BAC, further underscoring the unreliability of the extrapolation of this case. Accordingly, the serum plasma conversion and retrograde extrapolation or polation results should be excluded, addressing the issue of pure evidentiary admissibility, telling us that the records kept by the hospital shall be admissible and may be admitted by the court in its discretion as evidence in the court of the Commonwealth. So far as such records related to treatment and medical history of such cases, emphasis added. Similarly, the Commonwealth versus Dyer explains that medical records generated for evaluation and treatment purposes do not constitute testimonial evidence that may be admitted in evidence, Massachusetts, ... But both the statute at that point and seminal case on medical records admissibly pose conjunctive requirements, treatment and medical history, and evaluation of treatment. I.e. common factor believe the 2 authenticity is treatment. I don't know. Miss Reed's visit to Good Samaritan Medical Center on January 29, 22. The records produced there were explicitly not a part of any process of the administration of medical treatment. Commonwealth, blah, 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 was not connected to medical treatment. The Commonwealth failure to meet, to meet the statutory requirement means that the documented hospital records themselves can be admitted under the GL3C 223, GLC 23379 Hearsay exemption. There it is. Hearsay exception. Yes, you should have. And how they did it and who did it. Misread serum plasma ethanol concentration results should be excluded. Oh, that was a hard read, y'all. Hard read. Boy, Gerald, I got to read all yours. A warrant would only have been taken a few minutes. The chain of evidence has been broken. No, she would not have been in the hospital. 10 years. Okay. They have opened a big can of worms for the defense. If she was that drunk to give consent, she was grieving and crying. And why would somebody blow her a kiss of the brother of the victim blew her a kiss in the hospital? Yeah. Never understood that. Yes, ma'am. And for what reason they singled her out? Can you do? And the chain of custody would have been protocol following. Yeah. Who, what, when, where, how, and why they did that. That was the problem I have with this particular document. Okay. Next document to be opened. I want to see if I can close this. Okay. We're going to close that one. We're going to present. Share screen. Open window. Let's see if I can embiggen this without going through all that editing because I can't edit anyway. Let me see. It may not let me do that. I got to do the edit. So, yeah, I'm struggling a little bit with that. I struggled with it before. They were saying she bought a bunch of shots of liquor and was adding it to water. I don't drink. I wouldn't know what that means. I don't drink. I don't know. I drink this much and I'm ready to go to bed. Motion to impound defendant's motion eliminated exclude witnesses prior to criminal history. Now comes the defendant, Karen Reed. Ms. Reed respectfully moves this honorable court for order impounding defendant's motion eliminate to exclude witnesses prior history. They want to exclude witnesses' prior criminal history. Good cause, and this is for impoundment of has motion supporting exhibits because of continuous reference of confidential arrest records. Okay. It's 72. Let me go to the next one, which is going to be 573. Y'all ought to see my monitor over here. It's covered in documents. All Karen Reed that dropped today. It was crazy. I have not seen document dump like this in a long time. And we're doing good. Yeah, let's see how long this is one pager. Okay. Affidavit of Elizabeth Little supported defense motion to impound. Not going to read that. We've already done that. I got to get that monitor up. Hold on. Why are you not turning on? Everything's plugged in. This is a new monitor. You better work. Come on. Engage. It's not engaging from this. Okay, okay, so it's on, but it's not gaining information from here. So I'm going to unplug it and try and plug it back in, plug everything in, making sure everything is plugged in, on. Why aren't you working? Come on, man. You can see me bounce, but you can't. I can't see anything on monitor. Why aren't you staying on? Okay, it's not staying on. Is it the power cord? I don't know where the power cord goes. Okay, well, like that's not going to be a quick fix. Okay. All right. This is interesting, y'all. So here is the motion for sequestration. They want to sequester. The Commonwealth motion eliminate to sequester the above or below, actually. Below. Commonwealth motion eliminate for sequestration order and relief from that order of family members of the victim. The Commonwealth moves for an order of sequestration. All witnesses expected to testify at trial. So the defense came in and said, well, we want to sequester your witnesses now. They're coming in and saying, oh, no, honey boo boo, we want to sequester all. If we get sequestered, we're expecting you to be sequestered, period. End of discussion. You don't like it? Too bad. So here we go. The Commonwealth further requests that the court allows the following potential witnesses to be exempt from the sequestration. Oh, okay. So they want all witnesses but the victim's brother, Paul O'Keefe, the sister, Erin O'Keefe, the victim's niece, nephew, mother, defendant's father, defendant's mother, and the defendant's brother. They are wanting them. Decision concerning these sequestration witnesses are one with the judge's discretion. So they're saying that they're okay with these 7 people being in the room. Please. All right. Let's see. And this is being 2, 3, 4. Yeah, they're 2 minutes late. They 2 minutes late. Okay, enable editing. While that happens, I'll get it on screen. I clicked on it. I want you to share it. So the witnesses and the jurors still be stared down by John's brother. Exactly. But see, if John's brother is a witness and he sat and right across, I mean, within 12 feet, 12, maybe 15 feet of the jury, facing them, staring down and looking like a pissed off teenage boy on crack the whole time. Yep. The Commonwealth motioned to eliminate to allow the court identification. In court identification of the defendant in accordance with the rule blank blank on December 7th, the Commonwealth of Canton PD for Mass Court ruled that were an eyewitness did not articulate. Let me see. Can you get it? And the identification procedure before trial, good reason for an incorrect identification must first be shown. While in court, did not categorically succumb the good reason tonight. The court provides to exempt good reasons. Let me get back up here. Allows in court identification of the defendant in accordance with the rule announced on December 7th, 14. While the court did not categorically circumscribe when good reason tight, the court provide the following 2 examples of good reason. 1, eyewitness was already familiar with the defendant before commission of the crime. And 2, the witness is an arresting officer who was an eyewitness to the crime and identified would merely whatever that the defendant is in the person who was arrested her. So they're wanting people to identify Miss Reed every time they get up on the stand. They didn't do that last time. That was an extreme description of Paul O'Keefe. Yep. But was I not correct? He would, if he could have pounced and beat the hell out of somebody with just the snap of the judge's fingers, it would be done. He was shooting venom from his eyes. They're getting ready to come back. The court-based rule on common law principles and fairness did not address the subject under the constitutional principles. I'm trying to skim. While there are no eyewitnesses to the crime itself, witness observation of defendants close in time to the crime and the subsequent aftermath and the recovery of the victim's body. The circumstances must meet good reason standards. As in Canton, there's no out of court identification procedures conducted prior to trial. The Commonwealth intends to lay a foundation that the witnesses were familiar with the defendant prior to January 29, 22, the date, and the defendant is alleged to have murdered John O'Keefe. The Commonwealth witness include individuals who were friendly with the defendant and knew her through her relationship with the victim. This is not the case where a particular witness identifying the defendant based solely upon his or her memory of the defendant around the time of the crime. Such as the court stated in Canton, under these circumstances, the witness knew of the defendant, but the crime, the risk of misidentifying arise. Okay, so they're saying people like EMTs that didn't know her personally that were there, they want them to identify her. And I'm like, why? Why do you want to go through this? Everybody now know who Karen Reed is. There's no question on who Karen Reed is there? Do you know who Karen Reed is? Yeah. Okay. There we go. You know, and I did some stupid. I didn't even monetize. I forgot to monetize. Go figure. I wish they would monetize automatically, but no, I got to come in and click on monetize and save it and go through all this extra rigmarole. And it's so frustrating, y'all. It is so frustrating. So I got to go back and fix that. I know. I've lost a couple of pennies. Yeah. Whatever. Okay, done. So anyway, so they're basically wanting them to force the prosecution and the defense to make sure that she is identified by certain witnesses, such as first responders. Ah, okay. Common practice, nothing unusual there. I'm out and about with Diane. How were you doing, love? We's reading. We got a massive document dump. Thank God there's not 50,000 pages per dump. We got a lot of pages, but man, this is getting tight. We're going to stop here. We are back. And we've been actually in testimony, not
Robert, so
reading a
when you
bunch of
took over this case,
reading secretive
give us again
weird
the
phone calls.
approximate date that was.
It was approximately October of 2019.
Okay, so it was 2 years after the arrests of Monica Sementilli and Robert Baker, correct?
A little over that, but yeah,
Okay,
give or take.
and the prosecution was pending, shall we say?
Correct.
Okay, what was your role then at that time on the case?
It was to obviously assist with the prosecution. There was still a lot of interviews and investigative
try and fix this
things that need to
monitor.
be done on the case that was already pending, as well as suspects still outstanding that we were trying to identify and
Okay.
take into custody.
And eventually that person was identified as Christopher Austin, is that right?
One of them, yes.
Yes. Well, the missing murderer, killer was Christopher Austin, correct?
The person seen in the video was Christopher Austin, yes.
And you are aware that he has since pled guilty or no contest to the murder?
Yes. There is a deal in.
Right, that's fine. We can talk about it. He's pled and he won't be sentenced till after the trial is over. And the deal has to do with less time that he would do than if he had normally just been charged and convicted.
Objections to facts not in evidence.
Sustained.
And
Are you aware?
approach.
You gonna approach? All right.
Roberts, we'll get back to the deal. Let me correct one thing in the questioning that I had for you before we broke for lunch, and that was relating to all the calls and contact between Mr. Baker and the defendant, Ms. Sementilli, that was tape recorded in the jail cells and everywhere else in custody, as many as you could, and which were reviewed by you, and eventually some of them played before the jury, correct?
Correct. We're speaking of just the cell overhears?
Yes.
Okay, yes,
We'll call those overhears, if that's okay.
sure.
And I had talked about that, the decision to which one of the, if we had played all of them, it would be here days or weeks, correct?
Correct.
Okay. So a decision was made on which ones to play, and I said that was made by the prosecution, and actually it was joined by the judge and the prosecutor in terms of which items would be played before the jury and which would not, correct?
Yes, and I think there was certain parameters that the court had placed as well, limiting what the court saw appropriate for us to play.
Sure. And that had involved some explicit language is what is part of it, correct?
Yes,
Okay. But you're satisfied that the items that were relevant to this case were played before the jury in the last couple of days. Is that correct? I'll withdraw that. You heard all the tapes that were played to the jury.
yes, I did.
Okay. So knowing that those were not all of them, can you tell us the last date that contact between overhears between the defendant and Mr. Baker took place?
And we're talking still just the overhears, correct?
Yes.
Yeah, I want to say that it was January 2018, but I'm not 100% sure.
Okay. And I assume then that there were no more overhears obtained from that day to now. Is that right?
Correct.
Okay. So 25, as far as you know, there were communications overhears between the defendant and Mr. Baker. Is that correct?
Object, it's leading.
All right,
And it assumes facts, not evidence.
still ruled.
As far as overhears, I do believe that's the last.
Okay. And I take it that any additional overhears would have been recorded just like the ones that were played for the jury in the last few days, as well as the ones that were not. You follow my question?
If I agree with that, if they were determined to have evidentiary value that
Okay.
was important for the jury to hear.
Did this system of overhears, can you tell us briefly what that involved? How the law enforcement or the jail obtained those overhears?
So they were placed, the recording instrument was placed in the cells before the defendants were placed in the cells.
Which cells are we talking about? Because weren't they housed in different
Okay.
locations?
Well, it was the time, okay, so we're going to go all the way back.
Sure.
On the days, sure, the defendants would appear in court together for preliminary hearing settings and things like that, motions, whatever,
Just like a courtroom like this.
just like a courtroom like this.
Okay.
And on the days that we knew that they were going, or the detectives then knew that they were going to be at court on the same days, they would place them in cells adjacent to each other or either across or next to each other. And those cells were outfitted with recording devices.
So law enforcement or the jail personnel intentionally placed at that point the two defendants in the case close to each other, whereas normally that might not have been the case with normal inmates. Is that correct?
Absolutely.
And then the listening devices were placed in there, which also would not ordinarily be the case with normal inmates, correct?
Well,
I mean, if
I
you
don't
had
know about
two-
normal, but you can request it. I could request overhears in any of my cases. It's up to the detective and whether that's something they want to do in their case.
Okay, and I think we heard that this is only done in special cases, serious cases like this one.
I have to disagree with that.
Okay.
Yeah.
So it's basically,
You're conflating this with the Perkins operations?
no, I'm talking about the over here.
I understand what you're talking about, but what you said, very well.
Did I say the Perkins?
No, you did not say that, but
Okay.
very well.
Just like the Perkins operations.
I think
fair statement?
no, I think the Perkins are different because the resources are limited. There's one team for not only for our entire LAPD, but a lot of times they work for the entire state and city. Whereas the overhears are case specific, and it's really up to the detective in their case if they think they need additional evidence and that their defendants might talk to one another, that is something that they can request to be done.
Okay. So in both cases, the goal is to get additional evidence that they think they may need before they go to trial, correct?
The goal is to get additional evidence.
Okay. And in this case, the additional evidence was Mr. Baker and Ms. Sementilli, correct? Those were the two defendants who were the subject matter of this undercover procedure, shall we call it?
That is correct.
Okay. But in Mr. Baker's case, you knew by the time you came on that his DNA, his blood had been matched by DNA to blood basically all over the victim's house the night of the murder, correct?
Correct.
Okay. So there was plenty of evidence there to convict Mr. Baker. Fair statement?
It's irrelevant for opinion as to that.
Sustained.
Okay. What you were really looking for, and I mean in the entire LAPD District Attorney's Office, was additional evidence against Ms. Sementilli, who obviously her blood and so forth was not found in the house and was not present during the murder, correct?
I disagree.
Okay. In fact, from the very beginning of the case, and I'm referring back to February 14, 2017, when the DNA was first matched to Mr. Baker, correct?
Correct.
Okay. I know it had to then be tested more, but
Sure.
on that date, the LAPD was pretty confident they had one of the murderers, correct?
Yes.
But as we've heard, he was not arrested, was he?
That's correct.
Now, I know this wasn't your decision, but the decision of LAPD was to leave him on the street, as well as obviously the unidentified second murderer, in order to get more evidence against Ms. Sementilli.
I believe.
Compound and also assumes facts and evidence with respect to this.
Overruled.
I believe that the goal was to identify and get everybody that was a participant in this murder.
Of course. And the only evidence in general at that time connecting Ms. Sementilli to the murder was that she was having an affair with Mr. Baker. Correct?
I would have to refer back to the timeline. I'm not sure if they had the phone records at that point.
Okay. And obviously, phone records were obtained. We've heard testimony about them throughout the investigation. Correct? And those phone records, to a large extent, documented contact between Ms. Sementilli and Mr. Baker, both on encrypted phones and non-encrypted phones, correct?
Encrypted applications.
Okay, fine. So that was additional evidence that was being sought, correct?
Yes.
But that could have been obtained whether or not Ms. Sementilli was in custody or not, right?
I believe it was obtained.
Right,
when
when she was not in custody.
Correct.
Right. Had she been in custody, had you decided to arrest her and Mr. Baker, that information could have been obtained as well from her phones.
Correct.
Overruled.
Okay. So, in essence, you had Mr. Baker, but LAPD engaged in a detailed and I assume extensive and costly surveillance of Ms. Sementilli for the 4 months almost, or 4 months leading up to her arrest in June of the same year, correct?
I believe that the surveillance was directed at Mr. Baker and Mrs. Sementelli, not in an effort to get all the parties involved in the murder and to try and figure out what everybody's role was in the murders.
Okay, well, you knew Mr. Baker's role was killing Fabio Sementilli on the night of the incident, correct?
We know he was there in the house and was most likely the person that killed
Okay.
Mr. Sementelli.
By the way, did you, was one of the goals also when you came on the scene to locate, if you could, and determine what the murder weapon or weapons were in the case?
Trying to locate a murder weapon, yes.
So as far as you knew, when you came in what year now and month?
The end of 2019.
2019. This is 2 years after the arrest, correct?
Correct, a little over 2 years.
Neither murder weapon had been identified or recovered, correct?
Correct.
And that included knives that you had seized during the course, so forth, correct?
There had been no knives that were identified as being the murder weapon in this case.
And that included a knife that was recovered from the vehicle being driven by Mr. Baker, in which Mr. Baker and Ms. Sementilli were arrested in June of 2017, correct?
Yes, I had no knowledge that that was the murder weapon in this case.
Did you have, could I see Exhibit 56?
Yeah, I've lost a monitor. Dang it. I just can't do that. I'm sorry if I'm running all over the place because my main monitor up there is out. I don't see what everything's doing. And this is frustrating. I mean, I can still switch cameras. That's fine. But for some reason, this monitor is not connecting. I've changed the cords. I've done everything I know to do. It's getting no signal.
Is depicted in that photograph?
I have.
And when did you first see it?
I believe when I got the case, it was part of the crime scene photos, or not crime scene photos, but the evidence. If this is the knife I believe I'm looking at, it was recovered from the Mustang upon the arrest of Robert. Understanding when I came on the case that this the knife had already been analyzed, excluded, but it wasn't included. Not included or excluded. It just there was nothing to positively say that this was the murder weapon.
Did you review the reports of Detective Gable, who was on the case before you as part of your bringing you up to speed on the investigation and the case?
I mean, there were over 220,000 documents in this case. I'm sure I did, but I can't
Well,
remember everything
I'm
that
su-
he wrote.
All right, but I'm sure, and correct me if I'm wrong, since you came into the case 2 years later and 2 years after this exhibit was recovered, that you investigated whether that exhibit had been identified as possibly being the murder weapon or not the murder weapon, correct?
I did not investigate this weapon.
Were you aware that Detective Gable had excluded it as the possible murder weapon?
I w-
Overruled.
I wasn't aware that he excluded it. I was aware that there was testing and that there was nothing found in that testing that could say that this was positively the murder weapon.
And where did you get that information from?
That was in the investigative files.
Well, you didn't read a Quan report or a report of Gable that said it had been excluded?
I don't remember reading a report that said it was excluded. I'm not saying the report doesn't exist. I don't remember reading that report.
Okay. You knew it had been tested for DNA and that was negative.
Correct.
You knew that the coroner's report had indicated the knife that was used was a serrated edged knife.
I'm going to object to those 6 facts and evidence, and it states the evidence.
Overruled.
I would have to refresh my memory on that.
Did you review the autopsy report of the medical examiner?
I did.
And I assume, did you mark this report?
Which document?
Yeah.
Y'all, I'm pissed. The newest of all my monitors just blew.
The autopsy report itself, I do not think the report was marked.
Like the 621.
That's not the autopsy report.
Exhibit or non-exhibit.
Another monitor, and they're not.
May have been. Do you recognize this report?
I'm going to object again, assumes facts, not an evidence, and
Sus-
it states the evidence. It's
Sustained.
on the report.
I understand. Sustained.
I showed you an item. Have you seen that item before?
I have.
And this is an item that was prepared by either Detective Fillmore or Detective Plurdy, correct?
I'm
Or
gonna object
officer.
to assume it's speculative as to this witness.
Sustained.
Are there names on the report?
They are.
Okay. And you read the report?
Again, Your Honor, I object that this states the evidence.
Sustained.
You didn't read the report? I'm sorry, you didn't read we'll call it a piece of paper, okay? A piece of paper. Did you read this piece of paper?
I read the notes. Yes.
Okay, thank you. And partly based on that and the DNA results, that weapon was excluded as a possible murder weapon in this case. Isn't that true?
Based on those notes?
Based on those notes, DNA, and whatever other information you had, you were aware that it was excluded as the murder weapon.
Objection compound.
It's overruled.
I didn't put any weight into those notes, and that's an honest answer, because I go by the official coroner's report and what the coroner says. Honestly, I rarely even look at the notes from an investigator that attended an autopsy, because I've attended autopsies, and it's really for my sort of, for me, it's a baseline as I'm waiting for the coroner's report to come in.
Okay.
I don't take a lot of time to be accurate. I don't put wounds exactly where they are on the body.
You're not trained to do that.
Well, I'm trained to take notes, but
Not
I'm not
to do
trained
autopsy.
to do an autopsy, no.
Okay. So obviously, you're not doing the autopsy, you're relying on the medical examiner to do the autopsy, correct?
Yes, and to complete a thorough report is my
Right.
hope, yes.
And have you ever been one of the officers assigned to attend an autopsy in a case where the culprit or the suspect had not yet been arrested? In other words, an investigation or
Yes,
identified?
yes,
And you're aware that in serious cases where it's still the case hasn't been solved, sometimes LAPD officers attend autopsies, correct?
it's actually, we're required to attend.
Who requires you to?
Our department, the LAPD. I mean, there's certain circumstances if we can't, but even like in this case, when the investigative officer wasn't available, he sent another officer to attend that autopsy.
Okay, and the investigating officer at the time was Parshall, correct?
Yes,
Okay.
and Verna.
And were you aware that officers or investigators Purdy and Fillmore were told to attend the autopsy?
Objection. Calls for speculation, hearsay.
Sustained on the first ground only.
All right. So when you go and you attend the autopsy, do you
Thank
reach
you. It's
your
my
own
main monitor.
conclusions about the size of the wounds or where they were or what weapon possibly created the wound?
Objection irrelevant.
Not all of us.
No,
You rely on the medical examiner.
yes.
And do you take notes of what he is saying, or do you interview him afterwards, or how do you obtain his opinions on the crucial issues that you're there to observe?
I take preliminary notes just for my sort of edification, and
Based on what, if I could interrupt you?
it's based on, sometimes it's based on conversations with the doctor, sometimes it's based on visual observations in the autopsy suite.
But I take it you don't put down opinions as to what type of weapon, in this case a knife, was used to commit the murder, do you?
If it was something that was discussed with the doctor, I would.
Okay, so it's discussed with the doctor, and then you write a piece of paper that you turn in to the investigator, or who?
So I've never seen notes written on an autopsy like that piece of paper that you showed me.
Is there some reason why this would not be appropriate?
No, it's not that it's not appropriate. It's just not, it's not the way that I've seen it done.
How have you seen it done?
So when you go in for an autopsy, there's a.
Not personally, when you go to the.
Yeah.
I'm gonna object and ask if the witness could just finish her answer.
He's allowing that. He's allowing it.
Go on.
There's a little room that you go into where you put on protective clothing, and in that room, all of the forms that the doctor uses are available because the doctors go in there to change and they get their reports there, and we're allowed to take them. And most investigators will usually take I don't recall the exact number, but it has the body, has a version of the body, it has a head, it has a picture of things, and I scribble my notes on that as close as I can to what my victim looks like on the in the autopsy suite.
So just for example, I'm not marking this, but this appears to be an autopsy report, something like that with the, right?
Correct.
And this is the body intent,
Yeah.
drawn,
Right.
and then the notes are put on there. Correct?
Yeah.
What do you do, however, whatever you call it, and whatever piece of paper is put on, what do you do with it when you've completed it?
There's a section within the murder book for the autopsy, and I'll usually either put it in that section or I'll put it, there's also a section in the murder book for notes. It's up to the individual detective how they want to organize their murder book.
So in this case, if any notes were taken on the autopsy of Fabio Sementilli, it would be up to Detective Parshall as to where he put those notes or pieces of paper, correct?
Correct. And then in that instance, he could even put it, there's a section for other officers' reports. He could have put it in there. It's really up to him.
Now, in your investigation, which included, you said, trying to find out if you could locate the murder weapon, did you review the autopsy report?
I did.
And did you ever see the document that I showed you, the piece of paper prepared by Detective Officer Fillmore or Plurdy?
I'm sure I did. I don't recall it.
Well, after viewing it, didn't it play a role in the exclusion of item 155 that's above you at Exhibit 155 as being the murder weapon?
I can't really testify to that because I didn't exclude the knife, so I don't know what was played in the exclusion of this knife.
And eventually, Mr. Austin, are you aware, following his deal, identified that as one of the murder weapons, 155, correct?
I believe he said the knife looked like that. I'm not sure that he identified this specific knife, but I believe that he was shown a picture of the knife that was recovered from the Mustang, and he said, yes, the knife looked like that.
What if I told you he was shown the knife and asked if that was the knife used in the murder, and he said yes? Didn't you see that in the transcript of the proffer?
I don't recall.
Did you read the proffer?
I did not read the proffer. I read the interview and the Perkins.
So when you came on the scene as the investigating officer, is it fair to say you were still looking for the murder weapon?
Yes.
All right. You had no note in your report that murder weapon was found in the Mustang driven by Ms. Sementilli and Mr. Baker.
Correct.
Now, you were still obviously looking for the second. Well, let me ask you this. So did you review all of the surveillance, the results of the surveillance and whatever other investigation took place during the 4-month period between the time of the murder and the arrest of Ms. Sementilli and Mr. Baker?
Are you talking about all the surveillance even prior to the murder?
Well, how much surveillance was there?
Well, there was all the video that was captured on the day of the murder, of course. And then there was some video and photographs that were captured from GND when they followed the defendants, and SIS when they followed the defendants.
Okay, and was there any evidence during the surveillance that established anything other than they were having an affair? Regarding Ms. Sementilli?
Well, yes, I would say of course, in the video that was the day of the murder, I think there's a lot of stuff that corroborates that Mrs. Sementilli was.
Well, we all know about the
Okay.
day of the murder and what was recovered and so forth and the DNA and everything else. I'm talking about following the decision not to arrest either defendant, but especially Mr. Baker, during that 4-month surveillance period, was any evidence recovered tying Ms. Sementilli to the murder?
Circumstantial, I think, evidence.
What, that they
In
were
my mind.
having an affair?
I don't think that the way that Ms. Sementilli was behaving is something that I would expect somebody that lost their husband to behave.
Fair enough. And you believe that because she was cheating on her husband even before the murder and continued to commit adultery really before and then cheating afterwards, that meant she was likely the murderer.
It was very suspicious. It was circumstantial evidence that went in the box that included her and did not exclude her. And You keep putting stuff on one side, exclude, include, and
Okay.
it was evidence that included her.
And you put the affair as include in the box.
I put the post-murder behavior
Right.
in the box that included.
Well, let me ask you this. You've done a lot of murder investigations, I assume, correct?
Yeah.
And
Subjective.
a lot of questions, hypotheses, hypothetical questions were asked. One of the things a murder person who planned a murder with her husband, her lover would have done is maybe have no contact with him after the murder to make sure there was no evidence against her, right?
I'm gonna check that calls for speculation.
Sustained.
In fact, in this case, Ms. Sementilli invited or allowed Mr. Baker to come to the house 1 or 2 days after the murder itself when others were paying their respects, correct? You were aware of that, right?
Yes, he did come to the house during the memorial.
Were you aware that he had also sent a message saying, "I'm sorry"?
What I'm aware of is that there was a message that was deleted right before the I'm sorry. So I have no context for what that I'm sorry meant. It could mean,
Okay. But it was sent by Mr. Baker and it was sent to Ms. Sementilli the day after the murder. Is that right? Or the day of the murder?
I don't think it was the day of the murder. It was either the day after or 2 days after.
But after it was common knowledge in the press and so forth that Fabio Sementilli had been killed.
Correct.
Okay. At any time were wiretaps thought to tap the phones or the car or anything else of Ms. Sementilli and Mr. Baker to see what they were saying to each other?
There were no wiretaps in this case.
But there were tracking devices, correct?
Correct.
And that was to determine where they were going?
Yes, because I believe they were trying to identify the outstanding suspects.
Okay. And at times, an undercover officer was actually stationed in an automobile right next to where Miss Sementilli was.
Yes.
Parked, correct?
Right.
And she was crying, looking at her phone, and was overheard saying, "How could I be so stupid?" Right?
I'm gonna check, John, as far as just cumulative.
It's overall.
Is that
Yes,
right?
yes, I remember that.
Were any other statements overheard, as far as you know, during this 4-month surveillance?
I don't recall.
I mean,
It's
they
possible.
were seen going to restaurants and bars, correct?
Correct.
Miss Sementilli was seen grabbing the genital area or hugging a bouncer, correct?
Correct.
So there was a lot of evidence that was found basically showing her acting somewhat promiscuous and certainly still
Somewhat?
having Robert Baker as her lover, correct?
Yes, there was.
And you considered that proof that she was in on the murder?
I considered her behavior as suspicious and it could not exclude her from being in on the murder.
And excluder became an important issue in the case as it related to insurance proceeds, correct?
I believe that was something that she wanted to happen.
Well, if she was not involved with the murder, she was entitled to her insurance, correct?
Correct.
And half of it was going to the children, correct?
I believe so.
Okay. And you were aware that she had made several requests of law enforcement as to what was going on with the investigation.
Sure.
And in fact, there were tape recordings of numerous calls made to Detective Parshall back and forth in which insurance was discussed, correct?
Yes,
Did you listen to those calls?
I did.
And isn't it true that throughout those calls as well, or in many of them, she was inquiring what's going on with the investigation? Where is the person who did this? What progress are you making, correct?
I believe that she was trying to find out. Again, the behavior on those phone calls put her in the included box.
So you're saying that an innocent person whose husband was killed would not have been, after 4 months, hounding the police to find out if they'd made any progress in the murder investigation?
I'm gonna call, object calls for speculation.
It's argumentative, so stand on that ground.
But you are aware that every time she called and asked about that, there was a ruse going on by Detective Parshall and the other officers.
Yes,
And the ruse was to have her keep believing that they were making progress. Yes, we've compared the DNA, but it only shows it matches Fabio. We're getting close. We're almost there. You're aware that that was continuously told to her throughout that 4-month period, right?
yes.
And then it was not unusual for her to call in a few weeks and say, so what happened, right?
I think there was an intense focus on the insurance and collecting the insurance money, and it became suspicious because of how often it was brought up, not only to the detectives, but to the Wella executives, to the Wella HR people, to family members, that it was brought up so much that, again, it became more than what you would expect from a normal person that wasn't involved in the murder.
Well, but your opinion was somewhat colored by the fact that she was having an affair with Baker as well, correct?
My opinion is colored by the circumstantial evidence that I believe points
Okay.
to her having something to do with this murder.
But what if I told you that the majority of those calls, tape recorded to Parshall, focused on what's going on with the case? When are you going to find who did this, as much, if not more, than talking about insurance?
I listened to all the calls. I think we have a different interpretation or opinion of those calls.
All right, so the calls would speak for themselves, correct?
Yes.
In the beginning, she needed help in figuring out how to file for the insurance with MetLife to begin with, correct?
I'm gonna object calls for speculation.
Sustained.
Well, at some point, wasn't she informed by Detective Parshall or LAPD that they had to submit something to MetLife, in effect clearing her before the insurance could be paid?
Same objection.
Overruled.
I think that was something that Parshall was saying LAPD had to submit, correct?
Yes. Okay. So that was another reason for her to keep calling and finding out if you submitted this to MetLife, yet that we've been cleared, including her children, right?
I mean, again, we have different opinions on.
I'm not talking about the amount of time, but that was
Okay.
one of the subjects that was raised in her
Sure.
calls as to whether or not MetLife had been notified that she had been cleared so they could issue the check.
Correct.
And in fact, one time she got very upset and said, "Can't you even clear my children? Are they suspects?" Remember that?
Yes,
Remember what the answer was?
I do not.
We're working on it. You think it's unusual for a mother to want her children, 16 and 18 years old, to be paid their share of life insurance?
Again, Your Honor, I could object, it's irrelevant, it's also argumentative.
Sustain on the second ground.
So getting back to the murder investigation, in all the 4 months that this surveillance was going on, was there one time when Miss Sementilli was overheard saying anything to the effect of, "Why did we do it? Why did I kill him? I killed him," anything verbally that she said during those 4 months surveillance that was a confession to being involved in the murder of her husband?
That's fair.
Well, I can't answer that because there were things that were deleted and apps that were deleted, and I don't know what
Okay,
all was said.
fair enough, but live surveillance could not be deleted, could it?
Correct.
and people and officers in cars sitting next to them and overhearing and so forth, that couldn't be deleted either, could it?
Right.
So whatever the reasons, there was no evidence gathered in which Miss Sementilli was overheard telling Mr. Baker or anyone else that she had been involved in the murder of her husband. Fair statement?
That she said that she
Yes.
was involved? Yes, from the stuff, from the evidence that we had available, there was nothing found that she admitted to being a part of the murder.
And in the overhears that we've just played to the jury over the last several days, and I understand your view of what she said in there might be different than mine, but my question is specific. Did you ever hear her say to Mr. Baker, "Why did we kill him? I wish we hadn't killed him," anything of that nature?
Not those words.
But the words that we all heard.
Yes.
Okay. If there had been anything more incriminating that she said on those overhears, it would have been played to the jury, correct?
Oh, 100%.
Okay. So you can say the jury heard everything that you and or the prosecution felt in any way was incriminating to her.
I would say 90% yes. But there wasn't an admission where she said, I killed him. We would have played that.
Okay. Was there anything that was not played that had to do with control that Mr. Baker had over her?
There were some discussions about control, but they were always related to their sexual relationship.
Okay. And one time he uses the word master. Is that correct?
They used master back and forth.
Did you investigate Mr. Baker's background to determine whether or not he had a history of, for lack of a better term, controlling or manipulating women?
Well, if you would include the sexual assault of a minor as controlling, I would say yes.
Okay. So he had a prior conviction for the sexual assault of a minor, correct?
Yes.
Now, in all fairness, how old was the minor, if you recall, about?
I don't, how is that fair?
Well, I mean,
Said in all fairness.
No. I guess what I'm
I
saying
think it's
is,
fair, whatever age.
you're absolutely right.
Okay.
But is it, what was it, a 6 or 7 year old, or was it a teenager?
Teenager.
Okay, fine. Not,
No,
believe me,
right.
excusing that for a second. So you had that in his background. Did you investigate the number of wives or girlfriends he had before Miss Sementilli?
I'm gonna check the relevance.
Total.
Yeah, I wouldn't say investigate, but it was part of the material, part of the investigation. I was aware that he had 2, maybe 3 wives. He was involved in the porn industry. He managed girls,
Dancers.
such
So
as.
he pornography and strip clubs and things of that nature were in his background, correct?
Correct.
And you learned that from talking to friends of his, correct?
Correct.
Some of whom testified in this case.
Yes, and you can Google, you can get a lot on Google too, and I think his name comes up on Google.
Okay. The jury's not supposed to do that, so don't.
Okay.
Don't say it. Okay. Then following the arrest of the 2 of them, well, let me ask you this. Were you aware that Detective Parshall, well, first of all, were you aware that Miss Sementilli was in Canada the day before she was arrested?
Yes.
Okay. And Detective Parshall called her, I assume, like, kind of make sure she came back. And in fact, she had flown to Canada several times or during the course of the investigation and always came back, correct?
Correct.
A lot of those had to do with events involving Fabio, honoring him and so forth.
Correct.
But there's never any evidence she went to Canada and was going to stay there.
Right.
Okay. But Parshall told her basically the day before that she had been cleared finally and was going to get the insurance money, correct?
Correct.
And she did fly back, right?
Right.
And she contacted Mr. Baker, correct?
Yes.
And I assume that was significant to you,
Yes.
correct? Okay. And she also contacted her family, correct?
Correct.
Now, do you know if Mr. Baker, upon hearing that, told anybody, boy, now we're free and clear, now we can go away, now we can get a house in Vegas, anything of that nature?
Not that I'm aware of.
Okay. And the next day they're arrested in the Mustang.
Right.
There was also evidence introduced concerning a switch from Viber to WhatsApp. Is that right?
Correct.
And that occurred, do you recall approximately when?
Yeah, I believe Baker downloaded it on the 25th, and
Of what?
I'm sorry, January 25th, 2017. I believe Monica downloaded it on January 30th or 31st of 2017, and Austin as well, all in that latter part of January.
And that was around the time WhatsApp was first made known to the public, correct?
I'm gonna check that as office speculation.
Sustained.
Did you determine whether or not, in fact, well, first of all, WhatsApp, I think you would agree, is not an app that's used primarily for criminals, is it?
I agree.
Viber is.
No, I think WhatsApp, Signal, Viber, it's just a choice of which one you want to use. They're all the same. They're encrypted. They all have the same scrambling technique where law enforcement can't get the messages.
But you're not saying it's not used by the general public in large numbers, are you?
I don't know.
Okay.
I have WhatsApp. I have Signal.
Okay. Did you know that the daughters, put in WhatsApp right about the same time that Monica did?
Seems facts, not evidence.
Sustained.
Did you investigate whether anyone in her family had in fact installed WhatsApp right about the time that she did?
No.
Were you aware that WhatsApp is a cheaper way of communicating across nations, like from LA to US to Canada or not? Did you investigate that at all?
I know that it is, you can message free.
Okay. So it has innocent uses as well. Fair enough?
Yeah, but in the totality of what's happening at the time and Viber no longer being used and then WhatsApp being downloaded by all the parties involved in this case, it's no longer innocent to me.
Okay. But anything and everything relating to Ms. Sementilli and Mr. Baker following the murder was not innocent to you. Fair enough?
Well, again, it's whether it goes in the exclusion or the included box, and it's something that is just in the totality and with all the other evidence that was coming in.
But it could
is
have
suspicious.
could have innocent reasons as well. In other words,
For other people, for Jessica and Isabella, yes.
or someone else could be having an affair and not be a murderer, correct?
Oh, sure.
All right. So there's two reasonable explanations for having an affair. One that you could be a murderer and one that you could just be a
I
cheater.
think there's probably many different reasons people have an
Okay.
affair.
Fair enough. And your job in this case was to find those reasons, if you could, that pointed to her being a murderer.
Correct. No,
Okay.
no.
Involved.
It was to include or exclude, to find everybody responsible in the murder, not just focusing on Monica.
Let me ask you this. As a result of LAPD's decision not to arrest Mr. Baker immediately upon learning about his DNA, there were no search warrants issued for the search of his residence for almost 4 months eventually after he was arrested, correct?
Correct.
So for those 4 months, if he had any of the weapons or any other evidence of the murder, money, coins, anything, that was not available to LAPD, because if they issued a search warrant, it would be alerting him that you were investigating him and therefore destroyed the purpose of the 4 month surveillance.
Correct.
Okay. Now let's get back to the second murderer. When did you first have information that Mr. Austin was a suspect in this case?
That would have been in 2021, I believe.
Okay, and what was that evidence?
That was I wouldn't even call it, he was a suspect. He was somebody we looked at. His name first came up to my attention in 2021 when because of the Facebook Messenger message download WhatsApp, a couple days after the murder.
By Mr.
By
Austin?
Mr. Baker to Mr. Austin.
Okay. So he became what we hear sometimes as a person of interest.
Yeah, it was suspicious. We were looking for things that stood out in the phone records that was different from the normal.
Did you investigate as to whether or not he was in Los Angeles? Well, you knew he lived in Anchorage, correct?
At the time that we had that message, it was believed that he lived in Fayetteville.
In Arkansas?
Yes.
Okay. And Fayetteville?
Fayetteville, yeah, I always get it.
Okay.
Fayetteville, thank you.
But when did you learn that he actually resided in Anchorage?
In Anchorage, I believe it was the end, mid 2022.
And why did you believe he lived in Fayetteville?
That was information that when Cy came on the job, was helped out with the expert, helped out with the phone records. One of the things we asked him to do was look at the phone records and identify numbers that stood out different from the normal patterns, like he talked about patterns of life or whatever. And there were 8 to 10 names that stood out in the phone records that were given to me.
As being
people that we should look at, because the records most of them were like
communicating with Baker
right after the murder, or communicating with Baker near the time of the murder when there was virtually no communication. So just things that were different from his normal phone activity.
But why would that lead you to Fayetteville?
There was Cy had done a little investigation, and that was the information that was given to me that I took, and I probably should have ran Mr. Austin at that point and just did my own due diligence, but I took that information and just ran with that information.
So the information from Cy Ray, is that who you're talking about?
Yes.
Was that the calls were being made to someone in Fayetteville?
No, that the message on Facebook Messenger was sent to Chris Austin, and that Chris Austin was either from or lived in Fayetteville.
So the information he gave you eventually turned out to be inaccurate.
Okay, sweet
Correct.
Magnolia.
Let me interrupt. I think we need a stretch. Let's get up.
Stretch break. Y'all know what that means, right? Come on now. Come on. All right, you guys, let's get some fun going. While I key up Karen Reed. That was a short-lived break here.
Detective Roberts,
Okay, there you go.
when did LAPD become aware that there were two vehicles involved in this case? One being the victim's Porsche and one being another vehicle, I think a Nissan Versa, is that right?
Yes.
I'm sorry?
Pound.
Overruled.
I don't recall the exact date. I want to say it was in 2017, but I don't recall the exact date.
Okay, and how was that determined?
I believe that came from witness Paula McCullum, who in her statement said that she rented a car for Robert Baker.
On the day of the murder?
The day of the murder from Enterprise Rent a Car, and then it was just backtracking from there.
That was a Nissan Versa, is that correct?
Correct.
Did you ever locate that vehicle?
Yeah, I did not, but the investigators did.
And it doesn't really have a trunk, does it? It's just like a hatchback back there. Isn't that right?
I'm sorry, I don't know.
Did you take a picture of it or?
There were pictures that were taken. The investigators tracked down the car. I believe it was in another state by the time they tracked it down. And they wrote a search warrant and they went through the entire car. And I know there's pictures within the investigation of that car and the trunk area.
And she was tied to Mr. Baker, wasn't she?
Yes. Miss McCollum?
Yes.
Yes.
In fact, a girlfriend of his.
Well, I'm gonna check. That calls for speculation, hearsay, and smooth facts, not an evidence.
Just stand on the first one.
Did you ever determine what her relationship was with Mr. Baker?
Same objection.
Oh,
I would call it friends with benefits. I wouldn't call it a girlfriend because she was married, but friends with benefits.
Okay, Mr. Baker had a lot of friends with benefits, didn't he?
I'm gonna object. Smooth facts, not an evidence.
sustained.
Was she interviewed by LAPD?
Yes.
You know if she's going to be a witness in this case?
I know she's on the.
Relevant, Your Honor.
Sustained.
Did she supply you with any information that Monica Sementilli was involved in the murder?
She provided us with circumstantial evidence that went in the inclusion box.
More circumstantial evidence.
Yes.
Talking about circumstantial evidence, you testified, I can't even remember because I know you've been on the stand off and on several days, but something to do with Mr. Baker being in a vehicle at Target, correct?
Correct.
And you showed video of the vehicle entering and moving and so forth. And then I think you testified to the fact that the vehicle ended up way in the back of a parking lot, way in the back of the Target lot. Is that correct?
At which, well, you could say that either parking spot was sort of towards the back. One was the side back, and one was sort of that little alcove in the very back towards that green container.
I'm sorry, what is our next?
That is 623.
Photograph of it looks like a building and some parking lot.
Very well.
I'm sorry, what number is this?
623. In fact, Your Honor, make it easier. There are 4 photographs. If they could be 623. We want to do 1, 2, 3, 4.
It'll be 623 completely, and you can have it A, B, and C, D, if you wish.
Yes, A, B, C, and D. I'm going to show you some photographs. You were at the Target parking lot, correct?
Yes, I went several times.
Obviously following the murder and when you became an investigator on it.
Yes.
Okay. And that was based on video that you had seen of cars going in and out of the parking lot, including those belonging to Ms. Sementilli and Mr. Baker, correct?
That was based on Monica Sementilli saying that she was at Target, and then also from the video that corroborated that.
Okay. Now I'm showing you 623, is that right?
It is.
Showing you 623A, do you recognize the scene in that photograph?
Yes,
And does that appear to be the location where Mr. Baker's vehicle ended up at some time in the Target parking lot, the date of the murder?
it does.
And I believe you testified that somehow he could have gotten from there to a location where Monica Sementilli's vehicle was near that Payless store without being seen by the Target cameras. Did I get that straight?
Without being picked up, yes.
Okay. But isn't it true that there's just no way to do that without going through or climbing fences or something like that?
That's not true.
Okay, so this is A. I'm going to show you B. Does that look familiar to you at all?
That looks like the area that's, I guess if you're facing it, that would be to the right of the alcove, but
Okay.
yeah,
And-
where the finger is right there, yes.
So it looks like it's locked. Was it locked the day that you went there?
I don't recall, but we didn't really pay attention to that. So if I recall the day we went there, there may have been items placed in there, but that wasn't an area of interest to us.
Okay, let's go back to A then, Mr. Babich. And you're talking about him exiting this route. Is that correct?
That was one of the routes, or you can continue straight and walk through the parking lot.
You got a pointer there?
You did. I don't see it any longer. It's no longer here.
I don't know what this is, but you can use it.
That's it.
Okay. So can you show us, you described a circuitous route, it sounded like. Can you show us the route?
Well, this was,
Your Honor, I'm going to object to counsel's testimony and ask.
Sustained.
Can you show us on that
there were
photograph where you started at least from?
There were two routes. He would have started from here. He would have to jump this fence. There is a door in the interior here
Okay.
that you would have to go through. When we were there, it was unlocked.
But
An
if it was
interior
locked-
door.
I'm sorry, go on.
There was an interior door that was unlocked, and if you went through that interior door, it took you into the shopping center.
All right, let's look at this actually is D. That looks like it's looking at that gate from the other side, correct?
Right, correct.
So you'd have to walk, you're saying he could have walked down that road, that alleyway?
Yes, and there was a door on this side that was unlocked to go through.
Okay, but again, you're talking about how many years after the murder when you were there?
It would have been 4 years after the murder.
Do you
But
have
there's also
Go on.
there's another easier way for him to go through that doesn't involve this alcove, and it's simply, if you can go to the first photo, if you walk just a short way through this parking lot, there's a driveway for vehicular traffic to go into that next shopping center. You can duck into that shopping center and then walk out to Ventura Boulevard.
Okay, but
I
the
am
photograph that's up there now,
right now. I
does
have
that show where the car was parked?
it. And now I'm doing my
The car was in that little alcove there.
Okay, so, and is that a location that the Target cameras can capture or could have in the date in question?
It was so far away because it's at the farthest end of the parking lot
Right.
that you could follow the car, because we saw the car leaving from where it was parked. And if you followed that car, it got blurrier as it traveled through the parking lot, but it ends up at this alcove.
Okay, but if the person I'm using my finger on 623A walked the way you said, would that not have been picked up by the Target camera?
Chuck and asked and answered.
I maybe shadows, and I'd have to look again, but I believe it was too far away. Otherwise,
Otherwise, you would have been able to see it on the.
I would have been
target.
able to testify to seeing it. I
Okay.
don't believe it picked up pedestrian traffic.
And that's one of the reasons, well, I will draw that. Can we see the next photograph, Mr. Babbitt? This is E. Is this the door that you said was open, perhaps?
Perhaps, without seeing the entire,
The end of the, on D, the end of the walk.
I don't know what's around this corner here.
Around the corner, what I told you, that's what's around the corner, that box and that little dead end.
I'm gonna object to the student's facts, not an evidence.
Sustained.
Okay, but we can remove that. Could we put the first one up there again? But your theory is that Mr. Baker walked in front of the building along to the left as you showed us a second ago, not through the gate or over the gate going backwards.
That was always my opinion. That would be the easiest way to walk
Okay,
without having to, like you said, jump fences or do things like that.
and then can you tell us again then how he would get from there to where Monica Sementilli's vehicle was?
Do you have the photographs that?
Yes. Your Honor, can we have marked as next 624 A, B, C, and D, Your Honor?
Yes.
All right, I'm going to show you in a second some photographs where I think you testified Mr. Baker could have ended up without being observed by the cameras.
Sure.
This is A. Now, there is a Payless store a little farther down in the middle of the photograph. Is that right? Or you tell me.
Well, there was,
There
and
was.
this is where he would end up if he, I can't really testify to this photo because this photo doesn't, except for this far end here where the Payless used to be, I think if I'm if I,
This better now? Is this B? This is from a more of a distance. Can you see?
For the record, which exhibit are those?
This is 624B.
Thank you.
On this photograph, can you see where Miss Sementilli was parked?
well, I'm trying to, if the entrance is here,
Okay,
is it? I mean, this is your photo, so I don't know how these photos were taken, so
that's actually Mr. Dawson's photo. So,
I don't know how these photos were taken, but
and he'll-
I believe this is the entrance.
yeah, see the sign up there that says Target. So
Yeah,
that
I
looks
believe
like-
she entered here. I mean, if you can zoom out, make it not so close.
There you go.
She came in here. This was the Payless at the time,
Okay,
and he came around that building. So he was on the back side of that building.
well, you're
around here.
hypothesizing that's how he got. He didn't see
Your Honor,
him.
I'm gonna object if the witness can just answer one.
One moment. You done with your answer?
Yes.
Continue, Mr. Baker.
Your testimony was where you thought his route could have been without being picked up by the Target cameras, correct?
Yes.
You don't see him on any of the Target cameras and can't even see him getting into Miss Sementilli's car, correct?
We see somebody getting into Miss Sementelli's car.
You believe it shows somebody getting into the car?
I do.
Okay. And what about seeing that person before he gets into the car? Where's he coming from?
coming from that side of the Payless
And you
building.
can see that too?
Yes.
I see. Well, we'll get to that. You see was there a doctor's office that I'm showing you right now? You see the doctor's office sign? Was that Bahari, Bahari Medical Group?
Is this part of 624 council?
Yes. C.
Thank you.
Was that, well, you recognize that sign?
I recognize it from the current photos. I do not know if Bahari Medical Group was there in 2017 or if that was all part of the Payless.
Okay,
The strip mall has changed.
of course. But you do know that there was a camera somewhere on that face of those buildings that would have picked up whether or not Mr. Baker got in or did not get into Miss Sementilli's car at the time of the day of the murder, correct?
I believe that there was a camera on that building. I do not know if it would have picked that up, but I do know there was a camera. And when they went back to that building, when they realized that that building may have been relevant, it had already been taped over.
And that was because it was only active occurrence for 30 days, correct?
Correct. That is my memory.
So you're saying it took over 30 days for them to determine that the Target parking lot was a important piece of evidence in the case?
I'm gonna object to Sue's facts and evidence and calls for speculation.
It is argumentative as well, so staying on the second ground as well as being argumentative.
Can you look at, Mr. Babbage is going to show you what looks to be maybe, no, leave that up there if you would. A little white, see that white camera?
I do.
And this is a current a photograph taken a few months ago. I take it you saw that camera there the day you were there?
I'm gonna object to Sue's facts and evidence.
Sustain?
Did you see that camera there the day that you were examining the scene?
I don't remember.
Well, how did you know there was a camera that might have caught Mr. Baker if it had been accessed within 30 days in 2017?
I read that in the investigation.
Okay. So for whatever reason, no one asked about that camera until the tape was gone, correct?
I'm gonna object to Sue's facts and evidence.
Sustain.
Well, you didn't see anything in the investigative report that showed a video of closer video of Miss Sementilli's car and Mr. Baker getting into the car. You didn't see anything of that nature when you became the investigator.
You guys,
Did you?
thank you.
I don't
Bless you.
believe that this whole area, that the
my God.
investigators or anybody knew that that was even relevant at the time that they were out canvassing. They went out and they took several videos from the Target where Monica said she was that day.
Okay, but one of the videos showed her entering the Target and stopping in a parking place where you
Sorry, I
are
just
claiming
finished
Mr.
my
Baker
homework.
entered, correct?
Yeah, I believe
so
then after you
Thank you
see that video, then they go back and they realize
about the thing. Thank you
we
so much.
we might need the video from Payless. And they went back and it was no longer there.
But they had interviewed her the day of the murder and knew that she had said voluntarily that she had been to Target and then Ralph's, correct?
Yeah, and so they went out to Target and then Ralph's and collected all the video. They didn't know that this specific corner would be so important
Okay,
until they viewed the surveillance.
so that, if it had been available, a camera might have been able to catch the actual location of where she was parked and confirm whether or not Mr. Baker
Oh, yeah.
entered or not.
Yes,
Same objection.
they do still count.
Sustain.
Well, then why does anyone care that it was over 30 days?
Same
Thank-
objection. Also
No,
relevant.
no,
Overruled.
I'll look.
I guess I don't understand your
Well-
question. Why does anybody care that
Well,
it's
they-
over 30 days?
Didn't they go out and try to get the video from the camera on the medical group or the Payless?
Yes, once they determined that it was important because somebody got into Monica's truck, they went back to the Payless to collect video and it was no longer available.
Okay. you
Anytime y'all give me, you're going to get
Well,
a
let me
bunch
ask you
of
this.
entries.
You,
So yes, I will give
um,
it to you.
you didn't read, well, I'll withdraw that. Obviously, Ms. Sementilli was incarcerated when you came on the scene. But I think you read over the interviews of Ms. Sementilli by several officers or detectives in which she described her actions the day of the murder. Is that correct?
Yes,
I know there was one taken the day of the murder. She was interviewed, tape recorded. Do you know how many other times she was recorded and interviewed and recorded?
after her arrest or
Yeah, no,
the entire
before,
thing?
after the murder.
After the murder.
Right. Where you could learn what she had previously said about her actions,
We've got some
and
reading.
where she had driven and come from and came from and went the day of the murder.
I believe it was just the interview that
I'll still count it.
upon her arrest, and then the Perkins, and then the overhears.
Yeah.
Well, but isn't it true that she was re-interviewed by Parshall or Teller to take us again the route that you took Ralph's and Target and so forth to see if there was any inconsistencies in her statement? Wasn't that done?
Was it not on this? My recollection was on the same day of her arrest. I may be wrong.
Okay, but you opined, I think, that the time that she took getting from the Ralph's parking lot to her home took longer the way she described it than when you did the route going many different routes, correct? Did I get that right?
I did do many different routes. I also took the route that she said, and I did it different times of day and on the same time of day
For what purpose?
to try and see if it ever took me 11 minutes to get there
Because it took 11 minutes for what?
for Mrs. Sementilli to get there.
Based on the route she said she took, correct?
Based on the time we know she left, the timestamp on the Ralph's video and the time that Jessica's on the telephone and we hear Monica come home.
Okay. Now, did you have any video or did the LAPD acquire any video from Ralph's that showed her leaving the Ralph's parking lot?
Not the parking lot, no.
You knew from the video what time she entered the store, correct?
Yes, and what time she left.
And what time she left, she was carrying some groceries, correct?
She was carrying one small bag of groceries.
Okay. And then she walks to her car. Do you see her get in her car?
No.
So when you're saying it took 11 minutes for her to get home, you're timing it from the time she leaves the scene of the camera when she leaves Ralph to the time she arrives at her residence.
Yes.
So you don't know what she did before she even got to her car, if anything, right?
Well, I do know she wasn't on the phone.
Okay.
From
You
the
don't know
phone
if she's smoking a
records.
cigarette?
I don't know if she was smoking a cigarette.
Okay. Or stopping for any other reason, or dropped her bag or picked it up. You don't have any idea what she did before she got to her car, correct?
That's correct.
All you know is she was not on her phone.
Yes.
And then you don't know when she was driving. Well, let me ask you this. Do any of the surveillance cameras in the area, did they ever pick her up? That is her car captured on video, leaving the Ralph's and tracking it until it got to the camera we know shows you coming up Oakdale, Queen Victoria, and into the driveway.
Yes. My recollection is that's the only video we have is her coming back into the neighborhood.
So again, you don't know what route she took coming home, correct?
Well, we know the route that she said she took.
Okay,
coming home.
you don't know if she stopped for any reason?
She didn't say she stopped for any reason.
Okay. And
I believe she was asked
okay.
and did
But-
not say she did.
So you're saying, to be frank, she intentionally waited so she would not get there and see the murder taking place, right? Isn't that your hypothesis?
My hypothesis is that it took her 11 minutes to get somewhere that usually takes never more than 5. And it was very close in time that we see the suspects leaving. So,
That was suspicious to you.
yes.
So being the man interrupt, let's take our afternoon recess for 15 minutes. The admonition applies.
Only 15 minutes. So now, guys, we get to continue reading more Karen Reed. This is going to be, I'm doing pretty good on reading the Karen Reed. I think we're getting pretty getting through it. A lot of them are one pagers, so there you go. I'm going to do this. Let me get this like I had it. Grammatically, you can close. I don't need you right now. Okay, stop sharing screen. Share screen. Yeah, I'm talking to myself. Okay, guys, let me embiggen it. Oh, I don't like not having that monitor. That sucked, man. Okay, Commonwealth motion in limine to preclude references to redact the manner of death contained in the victim's death certificate. What? The Commonwealth? What shenanigans are you playing now in the Commonwealth? Tell me, what are your shenanigans? Can you give me an idea what your shenanigans are? There we go. The Commonwealth moves in limine in accordance with settled practice that the death certificate to be redacted from the means of manner of whatever. ... We have stated that with respect to the admission of the death certificate, the better practice is to redact the manner of death, such as the word homicide, sui, and accidental. Almost said it. My glasses are gone. I have to buy new frame. These are cheaters, and I need bifocals, so this is really a struggle. General Law C period 46, 19, as amended through ST, 1969, C period 478, end as now amended in the parenthesis SC. EST 1976 to 486.13, blah, 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 blah. Provides that nothing contained in the record of a death certificate has reference to the question of liability and cause for criminal trial, excluding from the death certificate the word unalive, self-unalive, or accident, or in this case, undetermined, is better and safer course. That I disagree with. They need to know. That doesn't make sense to me. But anyway, we'll keep reading. Where the defendant does not dispute the validity of the death certificate or the fact that John O'Keefe is deceased, the question of liability of his life solely, the liability is left solely to the jury. For the above reasons, the Commonwealth asks this court to preclude any reference to and redact the manner of death contained in the victim's blank's death certificate. Like they mentioned his name up here. Why did you redact that? Oh, that's a little bit cray-cray. But I have seen that in other trials where they have removed the manner of death, and both sides just agreed that he had deceased, and that was the end of it. I'm not too sure I'm happy with that here. But we'll see. Oh, we shall see. The Commonwealth respectfully requests that the court issue a ruling in limine that the Commonwealth may introduce certified copies of records to the Massachusetts Registry of Motor Vehicles. So you just want to be able to sit there and say, yep, that was her car. We're going through this quickly, y'all. We got one, though, that's got a lot of pages, I know. Is this it? I don't know. Editing permitted. Let me go. Okay. So this is a Commonwealth motion in limine to intend to obtain query records of potential jurors. Prior to swearing in the jury, the Commonwealth moves in limine the opportunity to inquire to the criminal records of jurors to determine whether they qualify to serve. See, inquire criminal record of jurors to determine whether they are qualified to serve. Over time, a limited exercise of peremptory challenges before the jurors are sworn in. Challenge for cause to be made before the juror is sworn to try the case. Inquire into the criminal record of jurors. Some case for the purpose to determine their qualifications to serve and their impartiality relied within criminal justice duties of the prosecutor protect courts. Okay. So they're basically saying, hey guys, we want to do background checks and get criminal records on everybody who's wanting to testify. I mean, be a juror, not wanting to be, and everybody who is to be a juror. And I'm like, why would you do that? Not everybody who is a juror has a clean record, but man, they can be darn good jurors. Sometimes those are the better jurors. They can read BS a mile away. Now comes the Commonwealth and moves the court to order defendant mark satisfactory offer to proof prior. I gotta hide something. To calling and summoning Norfolk District County Michael Morsi and what? Commonwealth moves that this court order that the defendant satisfactory offer of proof prior to calling or summoning Norfolk District Attorney Michael Morsi and victim's witness advocate Stephen as witnesses for finding that the district attorney and Mr. Nelson are not subject to any order of sequestration. What? Yeah, you can't talk to them. It doesn't matter. If you're a witness, you're a witness. You can't talk about your testimony once you take the stand. Snap. March 6, 2025, the defendant listed both the district blank and the victim's witness advocate potential defense witnesses. When a defense resorts to extraordinary means of calling prosecutor as a witness, he must make satisfactory offer of proof as to the need or the testimony from the prosecutor. Commonwealth versus blah, 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 blah. Generally, witness has burden of showing why the subpoena should not be enforced. A prosecutor should be called only when there is a showing that the prosecutor's testimony is relevant, material, and non-cumulative. Do you know why they're calling him? Because of that video I showed you yesterday. Yep, because that was all kind of bad yesterday. Defendant failed to show the prosecutor had personal knowledge or relevant factors bearing in officers' credibility that could not be elicited by any other means. The same principle holds for the advocate. See Commonwealth, blah, blah, blah. Witness advocate is a member of prosecution team and notes discoverable or protected by work product rule to the same. What? My computer did something. Same extent as a prosecutor notes. District Attorney Morsi is the elected official in Norfolk. Somebody says Norfolk District, and that's exactly why they say it, Norfolk. But they put a little more in it. A position he was first elected to in 2010. As such, he is elected advocate of the people and the chief law enforcement officer in the Norfolk District District attorney is the people's elected advocate for the broad spectrum, of societal something from ensuring the criminals are punished and for wrongdoing allocating limited resources. It's all garbled. Public protection. Mr. Nelson is employee of the Norfolk District Attorney's Office and is assigned to victim witness advocacy and was in this case and has been assigned to the case since January 2022. Blah, 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 blah. As the victim advocate serves an important and solitary function. They provide, I think, victim witnesses, families, assistance, information, support, and generally, cope with the realities of the trial. Criminal justice system and the disruption of personal affairs attending to the criminal prosecution during the time of personal trauma. During the trial, it is especially important that the advocate engage in an essential function of acting as a liaison between blank and witnesses and the district attorney's office, victims and witnesses. Neither the district attorney nor the advocate were participant witnesses to the charge before the court. To the extent that the defendant may want to impeach proposed Commonwealth witnesses as to the statements, the defendant has not shown an absence of alternate sources, purported information. Further, to extent the defendant is seeking either the district attorney or the advocate's opinions or observations regarding witnesses' mental impressions, research, evaluation of the evidence of the Norfolk County case. Such areas of inquiry reflects privileged work product. Boom. They think they have a mic drop. Work product rules exempt discovery, no proportions of records, reports, correspondence, memoranda, or internal documents of the adverse party, which are only the legal research, opinion, theories, or conclusions of the adverse party, its attorneys, and legal staff. Therefore, the Norfolk County District Attorney's Office respectfully requests that this court order the prior to the calling and summoning of the attorney and the advocate, district attorney and the advocate and defendant make a satisfactory offer of proof before this continues to that court, whatever. It's all garbled. Y'all, I struggle with that. I think they should be called. In my humble opinion, I think they should be called. Just because you are a part of Norfolk County and you think that you are, didn't mean to do that. I don't think they should be exempt. I think that if they, okay, we already read the chalks. I think that the district attorney and the advocate, I think they should be able to be questioned like anybody else if they have information that could be beneficial or impeachable. But I'm not a lawyer. I'm not in the system. I'm just a peon reading the documents. Okay, this is interesting, y'all. That's really already messed up. The Commonwealth motion eliminated to prohibit reference to a pending internal affairs investigation, sustained findings unrelated to this case, or unfounded allegations of misconduct. The Commonwealth moves to eliminate to prohibit disclosure or reference to any internal affairs investigations pending against the law enforcement witnesses. The Commonwealth further moves eliminate to prohibit the disclosure or the reference to any internal affairs investigations which sustain findings as they bear no relevance or do the findings relate to any bias exhibited those against whom I can't even read that. Internal affairs investigators are confidential, and disclosure investigations have not resulted in sustained of misconduct would have served no purpose other than to risk materially prejudicing the proceedings or confuse the jury. Moreover, the Commonwealth moves to prohibit reference to any civil lawsuit filed against Canton PD Sergeant Lank relating to an incident occurred nearly 20 years ago. No, his history, if he's on the stand, his history is just as open as anybody else's. I'm sorry, I don't agree with that. I don't agree with that. The federal lawsuit previously let upon by the defendant, there were no adverse credibility determination against Sergeant Link or any findings of liability. The case was dismissed by agreement of the parties. Because you agreed to do something to get it dismissed. Until the findings of liability have been made, the pending civil lawsuit constitutes an unsubstantiated allegation of police misconduct that does not tend to negate the guilt of the defendant. Finding the civil liability made against a prosecution team member in the performance of their official duties are objected to automatic disclosure and fall within the duty inquiry. Pursuant to blah, 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 if a police officer credibly is in a critical issue at trial, the judge has the discretion in the interest of justice to admit the evidence of specific incidents of the officer false statement in prior related matters. A judge, in deciding whether to allow a police officer witness in the interest of justice to be impeached with prior misconduct, may consider the age of the prior misconduct, the strength of the evidence of the misconduct, and simply establishing it, and whether the prior misconduct is probative and how the officer's conducts police something of guard jury investigations. In instance where there have been no substantial findings of misconduct, the jury should not be permitted to consider allegations of misconduct where disciplinary action is but one possible outcome. This is going to be, they're going to get that. They're going to get that. We only got 3 more documents to go. Wait a minute. Where is my court feed? Okay. The Norfolk, my court feed went down for a minute. I'm like, what the heck? Nope, I want that. Let me embiggen. The Commonwealth motion in blank to preclude the defendant from raising a third-party culprit defense. What? So you're basically saying that you want them to not be able to raise any kind of defense, no matter what it is. You're just, and she's going to give it to him. You know that. Now comes the Commonwealth that respectfully requests the court preclude the defendant from raising a third-party culprit defense. The defense position has chronically been fluid and unsubstantiated. I see a lot of impeachable stuff here. The defense, not impeachable, appellate. The defense claims has been notorious from its origin. Karen Reed, to be clear, you didn't, I guess, do it. We know who did it. We knew, and we know who spearheaded this cover-up. You all know. The first trial defense position transformation. We're going to everything, and maybe something will stay, some more. We're going to shuffle a lot of things around. This is a lot of weird. Most recently in its Fox 25 sit down, the defense responded to the question, in your opinion, there have been a few names that have been surfaced in the third-party culprit theory. Do you think if John was beaten up and attacked blank house, who did it? Defense counsel uttered, we don't know. The defendant quickly echoed, we don't know. Counsel further added, it's not for us to know. Somebody other than Karen is responsible for that. for the unaliving of John, but who did it specifically? Others know, but they're not talking. The involving response have vacillated from the unidentified certain villain, villacated from an unidentified villain to not whom is responsible, and have been the hallmark of the defense third-party culprit claim. And the defense is not entitled to simply engage in scorched earth tactics making blameless and incendiary claims about witnesses without any evidentiary foundation. My God, can you guys get wordy? Just say it. Make it short. Why do all this stuff have to be so flamboyant and just over exaggerated and spoken? Just give the bullet points and be done. Prior to the first trial, court made ruling relative to the defense third-party claim. The court ordered, based on the offer of proof Friday, I am well within my rights pursuant to the case law to exclude third-party culprit defense. I am not going to do that now. I am going to give you a chance to develop it, something relevant, complete admissible evidence, but you cannot open it. So that's my ruling on that. Whatever. Despite the court's clear ruling, the defendant launched into a third-party claim from the beginning of the opening statement. Karen Reed was framed. Her car never struck John O'Keefe. She did not cause the death. He can say that. He can say that. Bitch, please. And that meant that somebody else did it, followed by because the Alberts were involved and because they had close communications to the investigator, or relations, I think it's communications, to the investigators in this case. Karen Reed was framed for a red room she did not commit. The evidence identifying the establishing third-party culprit was never forthcoming throughout, and to this day continues to be non-existent in Massachusetts state, blah, 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 blah. I'm not going to read all that. Oh my gosh, y'all. We're going to take a break right here because they're back in court. And my brain is frying on this. This is our last document, I believe. I can't believe we got. I guess again, we're not going to see Baker.
Do you recall
Woman's
indicating that
all day.
the reason that, or one of the reasons Mr. Baker would have taken a circuitous route is because he didn't want to be picked up by the cameras by the Payless store, not knowing that they were going to be destroyed in 30 days. Wasn't that?
I'm gonna object. That's argumentative saying that.
I'll
My question is, wasn't that one of your theories when you testified a few days ago?
I mean, maybe in a different, I don't remember it as you're stating it.
Well, what was the reason that you gave, if you recall, why Mr. Baker had to take that circuitous route around the building, as you described it, to get to Sementilli's car? Why wouldn't he just walk from where he parked to the car?
I mean, yeah, if he knew there was cameras on the target, to go undetected by the cameras that were visible.
Okay, and I thought, correct me if I'm wrong, you also opined that he did not want to be caught by any of the cameras that were visible on the Payless.
Yes, at that point where he's actually meeting up with Monica, and I believe that there's statements to that effect in some of the overhears.
Okay, but going back to your theory, was they didn't know, or Mr. Baker didn't know, that the cameras would be destroyed in 30 days, so he was trying to avoid that when you say he entered Miss Sementilli's car.
I don't believe that he didn't know there was cameras. I believe that they were trying not to be captured on the target camera.
Not the Payless camera or the cameras on the wall there.
Correct.
Okay. let's go back to the route that Ms. Sementilli says she took and the time it took her to get home. Do you recall reading an interview of her by Parshall, Tellis, and Gable on May 18, 2017, about 3 weeks or 4 weeks before her arrest?
Is that the interview with the knock knock ruse?
Yes.
I don't recall reading it. I listened to it.
Okay. And in it, then whoever was questioning her asked her again to describe her route that she took from the target to home on the day of the murder.
I don't recall.
Wasn't that the route that you were relying on and saying that it shouldn't have taken her 11 minutes to get home?
I drove every possible route that you could drive, and it never took me more than 5 minutes was the longest it took me.
No, I'm not quarreling with that. I'm saying she had to remember 4 months later in an interview a route she took on the day of the murder from the Ralph's home, and remember if she had a cigarette or stopped for listen to music or whatever 4 months later. Isn't that true?
I'm gonna object, remember, it's now cumulative.
So rule.
I'm sorry, repeat the question?
Isn't it true that the route that you've relied on in terms of what Monica Sementilli said she took the day of the murder was from the interview of her on May 18th, 2017?
No, that's not correct. I didn't rely on any route because I drove every possible route you could drive, including the one that she gave.
Okay, but you would agree that it'd be hard to remember 4 months earlier whether you had a cigarette or stopped for some other reason on the way home.
Objection, speculation.
Just thing.
Okay. Now, whoever was in on the murder, I assume, would want to have given, based on your investigation, time for the Porsche to escape and leave the scene and not be apprehended 2, 3, 4 minutes after the murder.
Objection, recommended.
Sustain.
So, are you aware of when, first of all, Monica Sementilli actually arrived home?
Yes.
And what time was that?
Oh, gosh. Well, I'd have to refer to the.
Would you mind? Because I'm going to get into that with her daughter as well. So, do you have that?
I don't have it with me. I when I retired, I don't have any of the investigative materials.
No, but I'm sorry. You were shown that whole chart and video of cars coming and going and where they were and so forth the day of the murder, correct?
Correct.
All right. And referring back to that, it had Miss Sementilli arriving about a minute after Baker and Austin are seen leaving in the Porsche, correct?
I'm gonna object that misstates the evidence.
It's about.
It's vague because I don't know which Ms. Sementilli you're talking about.
Okay, thank you. Monica Sementilli arrived at the residence the day of the murder to find her daughter Bella there and her murdered husband, correct?
Yes.
Okay. We'll get to Bella, but how long, but there fortunately is a camera, the one camera apparently that was working in that whole area, that caught the people coming up, running up the street, and the cars leaving the house on the day of the murder, correct?
Yes.
And it caught the two joggers covered up, the two killers, and then it caught the cars involved leaving or coming, correct?
Correct.
All right. So we know that the two murderers are in the house. We know that the Porsche is seen leaving the house, correct?
Yes.
The next person to come home within a minute or less is Bella, correct?
Correct.
And right after her is Monica, correct?
Yes, about a minute after.
So By
When
that
it-
timeline, the Porsche basically had a minute or less to leave the area and get away clean without getting stopped or arrested by the police, right?
Well, I mean, we would assume that the police would know that a murder had occurred.
All right. Well, let me ask you this. When the 911 call was made, then the 911 operator asked, if they saw anything else and told that the victim's Porsche was seen leaving and give the license plate?
I believe when the 911 call came in, it came in more as a medical emergency because it wasn't reported as a murder because the daughter didn't know what had happened to her father.
Okay. And when did the police, as far as you know, from reviewing all the reports and records, first learn that a murder had occurred and a Porsche vehicle with the license number belonging to Fabio Sementilli had left the scene with the murderers inside?
I believe the police got to the location maybe within 20 minutes of the 911 call because it was originally, but I don't know that it was known that the Porsche was actually taken until the detectives arrived on scene and started conducting interviews, but I'm not
that's
100% certain on that.
So either the officers who got there first or the detectives, someone found out that night that the Porsche was stolen, and it contained the two murderers, correct?
Correct.
Was an immediate broadcast put out over the air? Look for Porsche license number containing two murders.
I don't recall.
In fact, it wasn't, was it?
Honestly, I don't recall.
It was listed the next day as a stolen vehicle, and a flyer went out. Isn't that what happened?
Governor, I'm gonna object that as soon as that's not evidence.
Overruled.
I honestly, I don't recall whether a crime broadcast was put
Do
out.
you know if any helicopters were flying over and were put over the scene to see if they could find the Porsche, or cars in the neighborhood? Police cars were traveling around to see if they could find
What
the
are you
Porsche the
talking
night of
about
the murder?
If I had the comments of the call, which should be in the murder book, all that would be in it,
Well,
including whether a crime broadcast was put out by responding officers.
Okay, maybe you can review that, but my question is, having reviewed it, why wasn't a broadcast put out immediately for that Porsche?
Again, I'm gonna object as soon as that's not evidence.
Sustained.
All right.
Move on.
Would you agree, as part of your investigation, that the murderers who were involved in this killing would have wanted more than a minute, if this was being planned, to get away from the scene?
Same objection calls for speculation.
Okay. Now, Bella Sementilli was the first one, Isabella, to find her father's dead body, correct?
Correct.
And she was there even sooner than Monica, correct?
Unfortunately, correct.
Absolutely. And do you know, also, isn't it fair to say that the murderers were at least in the house after 5:37 or 5:40 when sorry. Okay, so the murder takes place about they leave about 4:58 or 5 o'clock, is that right?
Sounds about.
And there's some communication between Fabio on his phone or voicemail or something that he leaves at 4:36 or 4:37, isn't that right?
Correct.
So it's clear, at least at that time, he was alive.
Yeah, you would assume that he was alive at that time.
And the Porsche is seen leaving the garage at what time?
Again, I would have to refer
Could you
to,
please?
I don't have any documents that have that timeline. It was a electronic timeline, but it should be in the investigative materials.
May I approach, Your Honor? I'm showing you a document that, and you tell me if you recognize this document. I opened it to the time of the murder, but it looks like it starts early in the morning. Do you recognize that? Haven't seen that timeline?
I haven't seen this timeline, but
Yeah, Your Honor.
Are we having fun yet?
so that's not a document from us. I have.
Oh, good for
I have
you.
a Viber timeline that might have the information in it.
Oh, but that's
Okay, here's the front page. You recognize that
that's
at all?
not a document. He's not agreeing with this. He's like,
I don't recognize this.
Okay, then why don't you look at your?
I can see if I have it.
nice try, dude. You see that smirk on her face? She's like, nice try. You guys pick up. We're almost done. We're gonna go to 4 o'clock there. Another 30 minutes. They should be breaking. Dang it! I thought we were gonna get
Your question
done
again,
on
Mr. Levine, was
yesterday.
what time do
Now
the
or
Porsche leave?
tomorrow.
Yes.
Y'all. Come on now.
Robert, I'm gonna have Mr. Banners put on the screen
Oh, finally, my neck
the
popped. That's all day.
video or the.
Sorry, I said finally my neck popped after all day of hurting.
I have 16:56 and 47 seconds.
I'm gonna have him put up. Would you look at the screen to your right?
Yes.
Okay. This is the.
Can I just identify, I know it's an exhibit, and if you don't know Mr. Levine, I'm sure Mr. Babbage knows it.
Exhibit 158, Your Honor, 258.
Thank you, Mr. Babbage.
Thank you, Mr. Babbage. Looking at
Look
that,
at that, she's all-
does that appear to be a document you referred to in your testimony a few days ago?
Correct.
Okay. So does it indicate at what time Baker and Austin were seen northbound on Winnetka, having left the scene of the murder?
Yes, 4:56 p.m.
And then Bella arrives at.
I'm sorry.
That's right.
Oh, that was on Wells Drive. So 4:53, Baker and Austin are seen leaving the residence.
Okay, 4:53. Now, Isabella returns to the residence at 4:54. Do you see that?
Correct?
So had she arrived a minute earlier, she would have come in on the murder, or at least the parties leaving the garage and the porch, correct?
Yes.
Now, you're also aware that prior to that time, sometime 5-10 minutes before then, Monica Sementilli communicated with Bella and vice versa. Is that correct? Do we have that? Can you put that up there? The okay. You see those calls, incoming, outgoing?
You would have to back up. That's to the eye doctor. Okay, Isabella's at 4:24.
Where is Isabella, according to your?
Over the well, he keeps going back and forth, but if he goes
Sorry. Can you
right
put
there.
up the whole thing, Mr. Babbage? Okay.
It's at 4:24 and 27 seconds. If you see that?
Yes, and then it goes to 4:28. There's another outgoing call. You see that?
Yep.
Now,
But that outgoing call is that is not to the daughter, that's to the eye doctor.
okay.
Yeah.
So there are a series of calls around 4:24, 4:27, and 4:28.
Yes.
4:30, between Monica Sementilli and her daughter Bella, correct?
Correct.
And it has to do with something with an eye doctor who's also called or calls Monica at the same time, correct?
Yes.
And it's clear that Monica Sementilli is in touch with her daughter Bella in one or more of those calls, correct?
If you can go back just one, just so I can see who the call is to. Not that one, but the, yes.
Okay. Now, what you're saying is Monica Sementilli on the phone, knowing that her lover and his partner are at the house killing her husband, knowing that Bella is going to the eye doctor perhaps, lets her do so and doesn't say anything like, wait for me, I'll meet you for lunch, I'll meet you for coffee, anything to delay her from coming to the house. She allows her to go right to the house and almost walk in on the murder, correct?
Yes.
Argumentative, and we also don't know what was said.
Excuse me. Is argumentative, sustained on that ground.
Move to strike.
You don't strike comments of counsel.
I'm
They are
sorry.
not evidence. Comments of counsel are not to be stricken. They're not evidence.
It wasn't that I was striking. It was the answer.
Any answer would be stricken.
Thank you.
Well, you heard on the overhear, Monica indicating that her attorney had learned that Bella was not intentionally delayed at all and was going to use that as evidence in the case. You heard that in the overhear, right?
She just states the evidence.
Did you hear something to that effect in the overhear?
That Bella was
That-
delayed?
That Bella was not intentionally delayed, even though she was on the phone with her mother. Her mother did nothing to delay her from going to the house and potentially walking in on the murder.
I heard a lot of self-serving statements on the overhears. And I also heard a lot of incriminating statements on the overhears.
Fair enough. You can characterize them any way you want. That's why we have a jury. Don't want to know if you heard that statement.
I don't recall in that specific
Okay.
wording.
But the essence of my question is, would you agree that according to this evidence, Monica Sementilli was in touch with her daughter 15 minutes before the murder took place, maybe less time? Correct?
I would have to see the timeline again. Just
Well, if she's talking to her at 4:24, 15 minutes would be 4:39. We know Fabio was alive at 4:37, so he's murdered right after that because the Porsche is seen leaving at 4:56? 4:53 they're leaving the residence.
I would agree that she's talking to her daughter because we
Okay.
have the evidence.
And you would agree that whatever she said to her daughter, and that's not in the record, her daughter went right home from the eye doctor and basically almost walked right into a murder. Correct?
Again, assumes facts, not evidence.
Sustained.
Well, she arrived home within a minute of Baker and Austin leaving the residence, correct?
Yes,
And immediately called 911.
correct.
And therefore, Baker and Austin had maybe a minute or two to get out of the scene and Baker to go park the car somewhere and Austin to be left out. And neither one of them were apprehended that night, correct?
Correct.
And it would mean that Monica Sementilli, if she was in on the murder, would have allowed her daughter, Bella, to be the first one to uncover or discover her father brutally knifed to death by Austin and Baker, correct?
That is what I believe, yes.
Okay. So there's no question, time-wise, she had to know her daughter was going to be there right around the time the murder took place.
Yes, and I believe that's why she sends out the Viber message to Robert Baker about, 5 minutes before her daughter comes home, 10 minutes, to let him know she's coming home.
So it's intentional.
I don't know that it's
You don't know
intentional.
what the message is to Baker, do you? The Viber message?
No, because it's encrypted app.
Oh, fine, okay. So you don't know whether she has any idea what Baker's doing or not doing. You just know there was a message back and forth, correct?
Oh, I think she knows what Baker's
Well,
doing.
I know what
Oh,
you
I
think.
do
I'm
too.
just
Woo!
asking you if you can tell by the fact there was a
Okay,
Viber
good
contact
now.
what the message was.
Good now.
In the totality of the day,
No, in
Your
the,
Honor, again, I'm gonna object and ask, well, if
she's not answering the question.
I'm trying to.
Oh, yeah. Now we're waking up. It has been such one of those cases, and now she is. This is her almost. If you put all the time that she's been on the stand for more than 3 days, y'all. Total time more than 3 days, probably pushing 4 days out of a 26-day trial. 27 tomorrow, or is that today? 27 today. So she is done with the bull. She has been examined, cross-examined, re-cross-examined, direct. I mean, she's
Withdraw the question
done.
and rephrase it. What does encrypted mean?
It's scrambled. We can't get the messages.
So do you
Like
know
she's
the
testifying.
contents of the message,
She's testifying over the same thing over and over again.
the Viber message from Monica Sementilli to Robert Baker that we're discussing, right? Shortly before the.
No, I don't know the content to any of the Viber messages.
Okay. Everything else is your conclusion, speculation, or intuition, or however you want to call it. That's your job as an investigator.
Your Honor, I'm gonna object again, counsel testimony.
There's argumentative, so stand on that ground.
Okay. So Bella arrives and then Monica arrives a minute thereafter, right?
Yes.
Now, are you aware that at some point Baker says to Austin, we better get out of here, Monica's at the target?
Hello, Blazy.
I'm gonna object.
How are you doing, love?
Facts,
It's
Your
getting a
Honor.
little.
I'll
I don't recall those specific words.
You don't recall that in one of the interviews or proffers of Mr. Austin?
I didn't listen to the proffer.
Okay.
If it's in the proffer, but
So you don't know whether Mr. Baker, there's evidence of Mr. Baker worrying about whether Bella's going to show up or commenting on the fact that, whoa, we just missed her. Anything of that nature? Did your investigation reveal that?
I don't recall anything of that nature.
Okay. Did the investigation that you participated in before you come to the conclusion that Austin was in the trunk of the car?
No.
Did you eventually learn that that's what he claimed?
Yes, that's eventually what he testified to.
Okay. But you didn't listen to any of his interviews before his testimony?
As I testified prior, I listened to the Perkins and his interview up in Washington, but I did not listen to the proffer.
So in his interview and his Perkins, and we all know what
Third or fourth
Perkins is,
time
an
he asked
undercover
that
officer that
question.
the suspect
Sorry, third or fourth
Austin
time. he was
doesn't
asked
know or is not supposed to know is working for the police, correct?
Correct.
At any time during those interviews, does he say that he was in the trunk of the car?
Not that I remember.
And in none of those interviews does he even say that Monica Sementilli planned the murder with Mr. Baker, does she? Does he?
I'm gonna object as to interviews. She only heard.
I know, it's also cumulative.
All right, I'll withdraw that. They speak for themselves. So let's go back to then how we get to Mr. Austin to begin with.
Sure.
After the Fayetteville inaccuracy from Mr. Ray, you learn that he lives in Alaska, right?
Yes.
And you learn that there's been contact between him and Mr. Baker, correct?
Correct.
Do you attempt to find out if Mr. Austin was in Los Angeles the day of the murder?
Yes.
And how do you do that?
Wrote two ways. I wrote a phone application, I'm sorry, search warrant for his cell phone.
So you knew his cell phone number.
I'm sorry. I'm all
That's
scattered.
okay. Take
I
your
wrote
time.
I wrote a search warrant for airline manifests.
Okay. And that was when approximately?
That was approximately, I believe that was late 2021.
Okay. So late 2021, you tried to determine if Mr. Baker flew down to Los Angeles at or near the time of the murder, right?
Mr. Austin. Yes, sir.
And what did you learn?
Well, he wasn't on any in that search warrant, he wasn't on any passenger manifests.
And the reason was you were looking for direct flights as opposed to layovers.
I was looking, not only that, because it's hard to write for a layover, but it was too wide of a search. I was looking for all passenger manifests because there was only a couple flights that flew from Alaska into LAX. So I wrote for the entire, who was on the entire flight, looking for a specific name. And it wasn't until I actually wrote for the name of Christopher Austin on any flight that I came back with that information.
Well, but you knew his name at the time you wrote the first search warrant, correct?
Yeah, I just didn't, I wrote it broad and then it didn't work out. So I figured out another way to write it.
And how much later was that?
Well, there was some stuff in between that.
Can you tell us if the stuff is relevant to your search for the second killer?
It is relevant.
Then please.
Okay. In January of 2022, we contacted federal agents up in Washington State, in the Vancouver area, and asked them to conduct surreptitious surveillance on Christopher Austin to try to capture his DNA so that we could compare it to the unknown samples in this case.
So the DNA, which is mainly in the form of blood, is that correct?
Correct.
From the
Yes.
family residence.
Right.
DNA came back to Baker. I assume some of it came back to Fabio, the victim, and perhaps other members of the family. I don't know, but you had some DNA that came back unknown. In other words, you don't know whose DNA it was because you didn't have a suspect to compare it with, correct?
Yeah, unidentified.
Unidentified. Okay. And in fact, the defense at that time was encouraging the prosecution and you to put that DNA in a CODIS.
That's incorrect.
Well, did the defense request that somehow that unidentified items be compared to whoever the suspect was, whether it's Austin or anyone else?
It's already gone into, it's overruled.
My memory at the time was that there was unknown samples and that the prosecutor tried to relay to the defense that they had to be tested through an accredited laboratory in order to be placed in CODIS. And we were assured that the court was assured that that would be done and released all the unknown samples to the defense.
But the defense
Can I-
was the
I'd like to
defendant.
I'd like to finish.
You may finish your answer.
Go on.
They were able to deduce a profile from that unknown DNA. Because they didn't use an accredited
Who's
laboratory,
Who's they?
the defense, I believe it was Baker's defense attorney,
Mr. Simran,
but
correct?
it wasn't the prosecution.
And it wasn't Miss Sementilli's attorney either.
Well, you asked me to explain, and I'm
Okay.
trying to explain.
Just let us know who the defense is.
She's finishing. Hold on a second, counsel.
Okay. So because it wasn't with an accredited laboratory, our laboratory could not
Yay.
upload it into CODIS without losing their accreditation. They can only work with laboratories that I know we had testimony of what it takes to get accreditation. And because that wasn't done, we have this unknown sample that we're not allowed to do anything. We can't even direct comparison to it, to an individual.
And this involved the attorney for Mr. Simran, who's got the DNA and
For
the
Mr.
unaccredited
Baker.
lab, not Miss Sementilli.
It involved the attorney, Mr. Simmerin, who is the attorney for Mr. Baker.
Okay. The defense was requesting that somehow it be uploaded and the right person be apprehended as soon as possible, correct?
And Your Honor, I would object. It's irrelevant.
That question sustained.
Well, this is all occurring in what year?
I believe that was in 2021. 2021,
Or 22?
2021, 22, the best of my recollection. It went on.
So knowing, well, when did you first learn that Mr. Austin had in fact flown down to Los Angeles?
It was the third search warrant that was written for manifests. I believe it was in December of 2022 or January of 2023. I think it was January of 2023. He was on a manifest with Alaskan Airlines.
Okay, and showed what?
That he bought a ticket via Kayak, which is a travel booking site, to fly out of Anchorage, Alaska, with a layover in Seattle, landing in LA at Los Angeles International Airport, 34 or 36 in the morning on January 22nd, 2017.
The day before the murder.
Yes, with a return ticket to return to Anchorage, Alaska from Los Angeles International Airport on January 24th, 2017, which he changed at the gate shortly after the murder, the night of the 23rd.
So you had evidence of Mr. Austin coming down the day before the
That's what
murder,
he testified to.
scheduled to go home the day after the murder, and then changing his home flight to the day of the murder.
Correct.
So I assume LAPD at that point went up to Vancouver or Alaska or got someone to go up and arrest Mr. Austin and find out what's going on.
No, we don't. It's more complicated than that when you're dealing with an individual that's in another state. Can't just go up and arrest them.
I understand, but you can get an arrest warrant, correct?
Correct.
And you could have that if it's signed based on the evidence you had at the time. You could have that forwarded to the law enforcement agency wherever Mr. Austin was living. Where was that again?
Vancouver, Washington.
Okay, it's in the United States, correct?
Yes.
So they could arrest him based on the arrest warrant, and then LAPD could have gone up and interviewed him and found out what was going on in 2022.
I'm going to object as soon as facts, not evidence.
Sustained.
Did anyone from the Los Angeles Police Department or any other law enforcement agency in LA you know of attempt to have Mr. Austin arrested in 2022?
2022?
Yes, when you said that you got the
That was
information.
2023.
2023, fair enough.
Yes.
And was he arrested?
No.
Why not?
The question was, did we attempt? Yes. Was he arrested? No.
They wouldn't arrest him based on your arrest warrant?
I didn't have an arrest warrant.
Did you seek one?
I went to the district attorney, tried to get a filing for the case. I didn't have enough at that stage to get a filing for the case. I was working with the FBI in Washington.
On this case?
On this case in June of 2023. They would not do a Perkins operation or arrest Mr. Austin without a UFAP warrant, which is a unlawful flight to avoid prosecution. They would not assist me in any operation and arrest without a filed case. They were not comfortable in doing it. There were too many variables, and they thought it put their agents at unnecessary risk.
So the result was a cold-blooded killer remained on the streets from 2023 to 2024, October 2024, correct?
I'm going to object argumentative.
Sustained.
So, did you seek an arrest warrant for what you needed from the DA's office?
I did.
And it was declined, correct?
I didn't have enough evidence at the time.
Did you have enough evidence to have officers from the Vancouver Police Department arrest Mr. Austin and question him and see if he would confess or give any information about the murder?
That is not a way that I did choose to run this investigation at the time. If I knew I didn't have enough evidence and I'm not sure that Mr. Austin is going to even talk to me, and I alert him that I'm looking at him for murder, and he says, pound sound, I don't want to talk to you, and I have to release him because I don't have a warrant. Now I'm letting a cold-blooded murder out for the rest of his life, most likely.
So being in the interrupt, we're going to take our afternoon adjournment this time till tomorrow at 9 a.m. The evidence applies not to discuss this case either among yourselves with anyone else or the former express any opinions of the cause is submitted to you. Have a good evening.
Yay, no. Do you know what the yay, no is? They were supposed to be finished with the prosecution 2 days ago. And they said, it was said that Baker was going to testify. And that's all I'm waiting for. I don't care about anything else. I am disappointed. I'm disappointed. We got to do this again tomorrow, y'all. Maybe tomorrow they'll close. We'll see. But all of that video listening to me was just a waste of time. But it had to be brought in because they had transcripts for the jury, and the jury could read the transcripts and see what was being said where we could not. Y'all. Okay, guys, I have to leave. I have to go take care of something. But in a minute, we're going to do the drawings. Let's see if this will work now because it said it had to be refreshed. Oh, nope, it's working. Yay, 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 yay. Come on. Oh, toxic. Woohoo. And you're not here. Here's the other one. From the other live. From the other live. Sorry. From the other live. Diddy! Yay! Wake up, everybody. Y'all, this is the slowest trial in history. Karen Reed's going to be fun after this. I guarantee it. I want to thank everybody. We got a lot of people to thank today. First of all, June, thank you so much for the gifted 5 memberships. Lady Jane, welcome new member. We need 2 more new members for us to get 13 custom. I make them, or you could suggest something and I can adapt it. Emojis. I may have an emoji contest. Gerald, thank you so much, beloved. June, you are just a sweetheart. Thank you so much. Thank you so much for Elena. Yes, and out and about with Diane. So they're talking monitor fund. For those of you who didn't know, my newest monitor bit the dust. It's gone. It's fried. It's done. Dun, 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 and it's just a few months out of warranty. Go figures, y'all. That's so frustrating, so I got to go get a new monitor. It'll be about a week before I can get a new monitor. So thank you so much for your support. All of you who watched on X and YouTube, thank you so much. We did have some interesting moments today, but we also had some very boring moments today. It is what it is. We got through all of Karen Reed's documents, but 1 or 2. We will go through those tomorrow. I know a lot of you will catch it on other content creators. That's okay. I'll be watching them too. I just have got to go take care of something, so I can't finish. But I just want to say again, thank you so much.
You guys bless me more than you ever know. I look forward to tomorrow. Lord willing, we'll be done with the prosecution. We did start the day with Lori Vallow Daybell, and she got a little pissy with the judge. And I was like, you didn't just say that. So, y'all, her trial is going to be full of piss and vinegar. So, we're going to be watching that so long as she does not get Karen Reed is done. And she tried to get another trial that she has out there that she's got to do another trial. And she tried to get that one to go the very next day. And the judge is like, She goes, well, I get fair and due process, boo. And I'm all like, oh, snap, girl. You don't know what you're doing. Shut up. I'm surprised her advising attorney didn't say, shut up. Oh, this is going to be wonderful. And she's worried about the camera angles. She did this live interview on Dateline and everything was on her and she was all, and then in court, she goes, well, I don't want them zooming in on my face. Last time they zoomed in on my face all the time and I don't want them zooming in on me. I'm all like, bitch, please get over yourself. Okay, guys, love you. Talk to you tomorrow morning. 11:30. I may come in a little early because we got Karen Reed stuff I want to deal with. So we'll see how that goes. Okay. But we will see you tomorrow. Thank you again so much for everybody who has given me super chats and gifted memberships and became member. Appreciate you so much for all those who have been with me. We got some anniversaries. This is my 1-year anniversary of my very first video that we went live on for this. But I don't consider my channel a real channel until it was monetized, so that I will be celebrating. So with that, farewell. Have a great night. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.